This is the 5 a.m. initial appearance calendar for June 4th, 2025. The court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. I'm going to be giving you your paperwork, and on the paperwork, there are going to be, most of you will be getting written release conditions. I'm going to be telling you what some of them are, but you need to be aware of all of your written release conditions. You are going to be responsible for following all of your release conditions, okay? So let's just start. Messiah Cockerhern to the podium, Jacob Smith to the chair. Hello, can you please state your full name?
Messiah Lee Cochran.
And your date of birth?
September 28, 2004.
Okay, now you have two cases before me this morning. You have one for failing to show up for a status for arraignment. Now and the underlying charge is for one count of criminal trespassing in the first degree as a residential structure as a Class 6 felony. You have an existing counsel. You have arraignment set for June 11th at 8:30 a.m. and a secured appearance bond in that case in the amount of $1,000. On your other case, you have a new charge. However, because you were on felony release, I have to hold you without bond. So, and I have the same name and date of birth. In this case, you are being charged with one count of possessing or using a weapon in a drug offense as a Class 4 felony, one count of possessing or using a dangerous drug as a Class 4 felony. I did find probable cause for these charges. I am appointing the legal defender's office to represent you. You have a status conference set on June 10th at 8:30 a.m. and a preliminary hearing set on June 12th at 8:30 a.m. And as I stated, I need to hold you without bond, and because of that, you have an evidentiary hearing regarding that bond amount, because I'm holding you without bond, on June 11th at 8:30 a.m. Okay? I'm sorry, what do you think? No. On the first case, you have a bond in the amount of $1,000. Okay? So you don't want to make that, because on the other case, I have to hold you without bond. But you're going to have an evidentiary hearing on that case on June 11th.
So I have to stay in jail to my next court date?
Definitely on June 11th. Your next court date is actually June 10th. But your evidentiary hearing date regarding the no bond will be on June 11th. So if that does get changed, that would be happening on June 11th.
Yes, I would stay in jail until?
Definitely until June 11th.
Okay.
Okay, so if you go to your left, you'll get your paperwork. Jacob Smith, please come to the podium. Kimberly Reese, please go to the chair. Hello, can you please state your full name?
Jacob Sean Smith.
Thank you, and your date of birth?
10/3/98.
Okay, is it March 10th, 1998, or is it 10 March?
They put it on wrong.
They put it on wrong? Okay.
Yeah, October 3rd of 1998.
Okay, well, I do know those numbers that are in your birth sheet, in your birth. However, there is a warrant out of Pinal County Superior Court for you, and that it is for a warrant for violating probation. You have an arraignment. I cannot appoint counsel for a different jurisdiction, so you have to go there, and they would be appoint counsel there. You have an arraignment set in Pinal County Superior Court on June 9th at 8:30 a.m., and their warrant is asking to keep you without bond, without any, and because it's post-conviction, we normally follow that.
My bond has already been posted.
Oh, well, there is no bond. There is no bond in this case.
So what I'm in here for in Maricopa County?
Well, for Pinal County Superior Court, it is an out-of-county warrant, and it was for no bond.
So how long do they have to come pick me up then from here? So I'm in custody right now in 4th Ave.
Okay, I
I
understand.
posted my bond, and they told me that I had to come see court for 24 hours, and I'll get released from here, and then I'd have to go to court out there.
Okay, well, Pinal County Superior Court should take you. I do not know exactly how long it'll take them.
But Ms.
Pinal County will be picking you up.
I know, but I'm not trying to. I know I'm hearing what you're saying, but so my bond's been posted for 24 hours. That's what I'm trying to say. They gave me a probation bond because my probation was Pinal County. They got moved to Maricopa. Maricopa posted. They said I have a bond for my probation, so I posted both my bonds, $2,500 for my charges, because I have. That's the reason I caught these charges is why I have a violation out there. So then they said that when I called the bond people, they say your bond is posted, but when I have to see a judge to get released from here, and when I get released from here, then I'd have to go to court from while I'm released.
When I looked at the warrant, there's no bond amount on it. It actually says to hold you without bond.
I know, I understand what you're saying, Miss, but
I understand.
Pinal never comes and picks people up from here.
No, yes, they do. I do not know how quickly they do so.
But how can they? So this is what I'm saying, Miss. I haven't violated that probation because I haven't got convicted of a charge out here.
Yes, it is post-conviction, though. I'm not saying that you violated your probation. I'm just saying that you are on probation.
Yeah, and I caught a charge out here, right?
Yes, I understand.
You know what I'm saying? I'm just lost, Miss. I don't understand it.
And that is why when you're in Pinal County, they can appoint counsel to help you out. Okay, I cannot give you legal advice.
But I'm still fighting this case, right?
Yes, I do not. All I can tell you is I'm dealing with release conditions on your Pinal County out-of-county warrant, and so I can only explain to you that on this case that I have here, it is case number CR 2022-00377 that I am required to set release conditions.
Exactly.
And I am affirming what their bond, what the warrant I have there is, and it's stating to hold you without bond.
But what I'm asking is because they said I'm supposed to get release conditions,
yes,
so I can be able to go out there and fight my case. Because
well, they will transport you.
So my bond was posted for no reason.
Okay, there is no bond.
No, Miss, listen.
There's no bond to place.
No,
I do not know why. I do not know what they could place.
Look, so I'm in Maricopa County right now for a burglary, and I'm on probation.
Okay.
They gave me 2 bonds for my probation and for the burglary, right? My probations were put together.
Okay. Well, I am looking at the bond that I have in front of me. States that there is no bond.
So what about my case out here?
Okay, I'm explaining to you right now that I'm holding you without bond on the Pinal County out-of-county warrant.
Well, if you get a chance, can you look at it when you're done with this?
I just looked at it again. I've looked at it 3 times while I've been talking to you. Kimberly Reese, please come to the podium. Justin Washington, please go to the chair. Hello, can you please state your full name?
Kimberly Reese.
Date of birth?
12/22/68.
You are being charged with 2 counts of aggravated assault with a deadly weapon as a Class 2 felony, 1 count of disorderly conduct using a weapon as a Class 6 felony. I did find that there was probable cause for these charges. I am appointing counsel to represent you. You have a status conference set on June 10th at 8:30 a.m. and a preliminary hearing set on June 12th at 8:30 a.m. I am setting a secured appearance bond in the amount of $75,000. If you make that, you will be on pretrial services, supervision, and you would have electronic monitoring to be installed before you are released from jail, and then with curfew to be determined by your pretrial officer.
Okay.
You are to have no contact with any alleged victims and not to initiate any contact with a complainant or witness. You're also, of course, not to have any possession of any weapons. All right, so if you want to just go to your left, you'll get your paperwork. Justin Washington, please come to the podium. Bradley Davenport, please go to the chair.
Good morning.
Good morning. Can you please state your full name?
Of course, it's Justin Irving Washington.
Your date of birth?
It's 07/27/2001.
Thank you. You are being charged with 1 count of possessing or using a narcotic drug for sale as a Class 2 felony, 1 count of possessing or using narcotic drug for personal use as a Class 4 felony, 1 count of hindering prosecution in the first degree as a Class 5 felony. I am appointing counsel to represent you. You have a status conference set on June 10th at 8:30 a.m. and a preliminary hearing set on June 12th at 8:30 a.m. I am setting a secured appearance bond in the amount of $50,000. If you do make that, then you would be on pretrial services with electronic monitoring to be installed before you are released from jail, and a curfew to be determined upon your pretrial officer. Okay?
Perfect. And basically, I would get like a bail bondman of some sort to...
You'd have to use a bail, yes, you have the opportunity to use a bail bond person to be able to make the bond, and then also you would be on electronic monitoring with pretrial services.
Okay. There's no way that maybe that bond is adjustable.
I'm not going to be reducing it. I read the form for it.
Okay.
You were trying to
Well, I
have that.
appreciate you.
Yeah.
All right. Got it.
Have a good day.
Yes,
Good to you.
Thank you.
Bradley Davenport, please come to the podium. Jose Hernandez, please go to the chair. Hello, sir. Can you please state your full name?
Bradley Allen Davenport,
Thank you. And your date of birth?
06/03/94.
Thank you. You have a warrant out of the grand jury. You are charged with 1 count of aggravated assault against a first responder as a Class 4 felony, 1 count of resisting arrest using physical force as a Class 6 felony, 1 count of disorderly conduct as a misdemeanor. These incidents happening on February the 8th of 2025. I am appointing counsel to represent you. You have an arraignment set on June 11th at 8:30 a.m., and I am affirming the grand jury's warrant, which is in the amount of a secured appearance bond in the amount of $25,000. You are not to initiate contact with any alleged victim or victims or complainant or witness. Okay?
Yes,
So if
sir.
you just go to your left, you'll get your paperwork. Jose Hernandez, please come to the podium. Jorge Gomez Fajardo, please go to the chair.
Hi.
Hello, sir.
Hello.
Can you please state your full name?
Jose Luis Hernandez,
Thank you, and your date of birth?
10/31/99.
And that was 1031?
Yeah, 99.
Okay. And you are being charged with 1 count of trafficking in stolen property in the 2nd degree as a Class 3 felony, 1 count of organized retail theft using an artifice as a Class 3 felony, 2 counts of organized retail theft merchandise Class 4 felony, 1 count of possessing or using narcotic drugs as a Class 4 felony, 1 count of possessing or using drug paraphernalia as a Class 6 felony, 2 counts of shoplifting as a misdemeanor. I did find that there was probable cause for these charges. I am appointing the Maricopa County Public Defender's Office to represent you. You have a status conference set on June 10th at 8:30 a.m. and a preliminary hearing set on June 12th at 8:30 a.m. And I'm setting a secured appearance bond in the amount of $5,000. Okay, if you just go to your left or get your paperwork. Jorge Gomez Fajardo, please come to the podium. Hello, sir. Could you please state your full name
Jorge Gomez Fajardo,
and your date of birth?
5/22/79.
Thank you. You are being charged with 1 count of possessing or using a narcotic drug as a Class 4 felony, 1 count of possessing or using a drug paraphernalia as a Class 6 felony, 1 count of shoplifting as a Class 1 misdemeanor. I did find probable cause for these charges. I am going to be appointing the Legal Defender's Office to represent you because of co-defendants issues. You have a status conference set on June 10th at 8:30 a.m. and a preliminary hearing set on June 12th at 8:30 a.m. And I'm setting a secured appearance bond in the amount of $5,000.
I've never missed the court date or anything. Doesn't that way at the OR?
No, I thought that the situation in this case merited a $5,000 secured appearance bond. So you just go to your left. You're welcome. Joseph Rascon, please go to the podium. Cecilia Garcia, please go to the chair.
Yeah.
Can you please state your full name?
So Joseph Rason,
And your date of birth?
January 17, 1987.
That was 87, correct?
Yeah, 87, 1987.
And you have a warrant for failing to show up for status conference. Your underlying charge is 1 count of possessing or using narcotic drug as a class 4 felony. You have existing counsel, so I'm not appointing one. It was just very quick. You have a status conference set on June 10th at 8:30 a.m. I am affirming the bond in the amount of $2,500.
Okay.
Okay, you just go to your left, we'll get that paperwork. Cecilia Garcia, please come to the podium. Scott McGinnis, please go to the chair. Hello, can you please state your full name?
Cecilia Marie Garcia.
Thank you. You have 2 cases before me this morning. And what is your date of birth?
11/21/85.
Thank you. And that is and I'm sorry, your full name again?
Cecilia Marie Garcia.
And that is the same name and date of birth I have for both cases. That is number 21 and number 30 on the docket. Going back to number 21, you are being charged with 1 count of possessing or using dangerous drugs as a class 4 felony, 2 counts of possessing a weapon by a prohibited person as a class 4 felony, 1 count of possessing a weapon in a drug offense as a class 4 felony. I did find that there was probable cause for these charges. I am appointing counsel to represent you. You have a status conference set on June 10th at 8:30 a.m. and a preliminary hearing set on June 12th at 8:30 a.m. And I'm setting a secured appearance bond in the amount of $2,500. On your second case, it is a warrant for violating your probation. I am appointing counsel to represent you. You have probation revocation arraignment hearings set on June 11th at 8:30 a.m. and that is set in the amount of secured appearance bond for $2,500 as well.
Okay.
Okay, if you go to your left, and then also if you do get out, be sure to contact your probation officer within 72 hours.
Okay.
Scott McGinnis, please come to the podium. And Jeffrey Shepard, please go to the chair. Okay, sir, 1, 2, 3, 4, 5, 6, 7. Okay, we have 7 cases before me. So we'll just go with, let's first just go with the one that's in Superior Court. And that is, you have 1 count of resisting arrest with the possible risk of physical injury as a class 6 felony. I am appointing the Public Defender's Office to represent you. You have a status conference set on June 10th at 8:30 a.m. and a preliminary hearing set on June 12th at 8:30 a.m. I am setting a secured appearance bond in the amount of $500. All of the other cases are set out of Surprise City Court. Let me start with number 9 on the docket. Number 9 is and again, could you please state your full name?
Scott Daniel McGinnis,
And your date of birth?
8/19/1983.
Yes, and let me just confirm. Yes. These are, all of these are, so number 9, 10, 11, 12, 13, 14, and 15 are all with the same name and date of birth. Just making sure it's clear. And so that included the Superior Court case that we just discussed. So going back to number 9 on the docket, it is a warrant out of Surprise Municipal Court. You are being charged with 1 count of possessing or using drug paraphernalia as a misdemeanor, 1 count of unlawful camping as a misdemeanor, well, urban camping It's actually 1 count of urban camping on public property as a misdemeanor, 1 count of criminal trespassing in the 3rd degree as a class 3 misdemeanor. If you remain in custody, you'll be appointed counsel at the next hearing. You have an arraignment set on June 10th at 1:30 p.m. You have a secured appearance bond in that case in the amount of $500. On number 10, it is a warrant out of surprise municipal court. It is 1 count of disorderly conduct, fighting as a class 1 misdemeanor, and that was a domestic violence offense. You have an arraignment set on June 10th at 1:30 p.m., and it is a secured appearance bond in the amount of $1,000. On number 12, it is another warrant out of surprise municipal court. Again, it is 1 count of possessing or using drug paraphernalia as a misdemeanor. If you remain in custody, you'll be appointed counsel at the next hearing. Arraignment is on June 10th at 1:30 p.m. You'll secured appearance bond in the amount of $500. On number 13, it's a warrant again out of surprise municipal court, criminal trespassing in the 3rd degree. And all of these, if you're in custody, you'll get counsel at the next next hearing. And your arraignment is June 10th at 1:30. You have secured appearance bond in this case in the amount of $150. On number 14, is at a surprise city court, a warrant. It's 1 count of criminal trespassing in the 3rd degree as a class 3 misdemeanor. You have an arraignment on June 10th at 1:30, and the secured appearance bond is the amount of $150. In number 15, same thing, a criminal trespassing in the 3rd degree as a class 3 misdemeanor, and it's June 10th at 1:30 for the arraignment, and it's $150 for the secured appearance. So if you just go to your left, you'll get all your paperwork.
Okay.
Jeffrey Shepard, please come to the podium. Alphonse Rosania, please go to the chair. Let me just quickly take a look at the warrants. Gets the return. 446. Okay. Yes, sir. Can you please state your full name?
Jeffrey Todd Shepard,
Thank you. Your date of birth?
3771.
Thank you. Here, I'm actually going to go back in here. I'm going to unclaim that. Let's see. You have a warrant for violating your probation. I'm going to appoint counsel to represent you. You have probation revocation hearings set on June 11th at 8:30 a.m. in downtown Phoenix, and I am affirming the bond and the secured appearance bond for the amount of $250. If you do get out, be sure to contact your probation officer within 24 hours. Because you have IPS, correct? Intensive? Yeah. Okay. So yes, be sure to contact them within that time period. All right, just go to your left and get your paperwork. Alphonse Rosania, please come to the podium. Branton Van, please go to the chair. Hello, sir. Can you please state your full name?
Alphonse Rosania?
Thank you. And you have your middle name is Louis?
Yes, correct.
Thanks. Date of birth, please?
May 18th, 1989.
Thank you. And you have a warrant for violating your probation. I'm appointing counsel to represent you, although it seems as though you may already have existing counsel, so it may just be affirming that. You have probation revocation hearings set on June 11th at 8:30 a.m., and I'm affirming the secured appearance bond in the amount of $750.
Thank you.
If you do get out, be sure to contact your probation officer within 72 hours.
Thank you.
You're welcome. Branton Van, please come to the podium. Heather Dooch, please go to the chair. Hello, can you please state your full name?
Bryson Van,
And your middle name?
Jazzy Tall,
Okay, and your date of birth?
12/14/90.
All right, and you have a warrant for failing to show up for a status conference. Your underlying charges are 1 count of possessing or using a narcotic drug as a Class 4 felony and 1 count of possessing or using drug paraphernalia as a Class 6 felony. You have existing counsel. You have a status conference set on June 10th at 8:30 a.m. and a preliminary hearing set on June 12th at 8:30 a.m. And I am affirming the security appearance bond in the amount of $500. Okay, so if you just go to your left, you'll get your paperwork. Heather Dutch, please come to the podium. I'm sorry. Oh, okay, which one do we have? Which one? But you need to call them ahead of time? Well, we should be able to be finished with Heather really quickly, so you may want to start calling. Will you call Heather? Yeah, I'm calling Heather right now. Oh. So, yeah. So, thank you. Thank you. And then Jose Lopez Corrales, please go to the chair. So, Jose, Cia, por favor. Okay, can you please state your full name?
Heather Nicole Dutch.
And your date of birth?
April 24th, 1989.
Thank you. And you have a new case out of Moon Valley Justice Court. 1 count of driving with a license that is suspended, revoked, or canceled as a Class 1 misdemeanor. I did find that there was probable cause for that charge. I could not determine whether or not you were eligible or not. So if you do want to counsel, you can request that at the next court date, and they can determine whether or not you were eligible. You have an arraignment set on June 20th at 10 a.m. I am releasing you on your own recognizance. So just be sure to show up for court at the Moon Valley Justice Court, and the address will be on your paperwork.
Thank you, Honor.
Okay, you're welcome. Okay, yeah, just go to your left and get your paperwork. Jose Lopez Corrales. Do I have to press something? Oh. Sorry, the other day it didn't work. That's why I had to use the phone. Hello, are you there?
Yes, I'm here.
Interpreter?
Yes, I'm here. Can you hear me? Hello?
Yes. Can you speak it a little louder?
Yes.
Thank you.
So, do we have the client online? I'm sorry.
The client is in front of me. Well, not the client, but the defendant is in front of me. I'm the commissioner.
Okay. Okay. Hola, buenos días, buenas tardes. Mi nombre es Francisco. Voy a ser su intérprete el día de hoy.
Okay. So can you please state your name and your badge number for the record? Okay, then, yeah, sometimes the page just like it's a little too much. Well, that was definitely gone. No, come on, stand on your phone. I'm going to quickly look at the search warrants real quick. Okay. Why do I need to see this? What do I need to that?
Maricopa.gov/LLRC.
Okay, I'm gonna get out of this one for the moment. Okay, where am I?
Hello?
Hello. Can you please state your name and tell us your badge number?
My name is Joseph. I'll be your Spanish interpreter. ID number 5914.
Thank you very much. And so now just to start interpreting, sir, can you please state your name?
¿Me puede decir su nombre?
José Alonso López.
José Alonso López.
Is your last name also Corrales?
¿Su apellido también es Corrales?
Sí.
Yes.
Your date of birth, please?
Fecha de nacimiento, por favor.
Diciembre 22, 1983.
December 22nd, 1983.
Okay. You are being charged with one count of theft, controlling stolen property as a Class 3 felony.
Usted se le está cargando el día de hoy con una cuenta de robo, controlar propiedad robada y como es un cargo serio de una clase número 3.
I am finding that there is probable cause for this charge.
Estoy encontrando que hay una causa probable para este cargo.
I've reviewed your financial statement, and I do not find that you are eligible for me to appoint counsel at this time.
He revisado sus estados financieros y no encuentro que usted es elegible para que yo le dé o le asigne un consejero en estos momentos.
If you have trouble hiring counsel, I would say
¿Usted tiene dificultad?
that you can move to have another judge re-examine whether or not you are eligible to get an appointed attorney.
Si usted tiene dificultad para conseguir una persona que lo defienda, yo diría que usted tendría que mover esto con otro, o sea, mover este caso con otro juez para que reexamine si es que usted es o no es elegible para que se le apunte o se le dé un abogado.
Just file a motion to have them appoint you counsel.
Solamente tiene que presentar una moción para que ellos le apunten a un defensor.
But at this moment, I'm not appointing counsel.
Pero en este momento no le voy a dar o asignar o apuntar a un defensor.
You have a status conference set on June 19th at 8:30 a.m.
Usted tiene una conferencia de estatus, está puesta para junio 19 a las 8:30.
And a preliminary hearing set on June 23rd at 8:30 a.m.
Y una audiencia preliminar que está puesta para junio 23 a las 8:30.
It is at the downtown court at 175 West Madison Street.
Eso sería en la corte del centro de la ciudad, en la 175 West Madison Street, en esta ciudad.
The address will be on your paperwork.
La dirección estará en sus papeles.
I am going to release you on your own recognizance.
Yo le voy a liberar bajo su propio reconocimiento.
That means it's your promise to appear for court.
¿Qué significa eso? Que usted promete aparecer para la corte en esa fecha.
So make sure you show up.
Asegúrese que aparezca.
Okay. If you go to your left, you'll get your paperwork.
Si va a la izquierda, ahí le pueden dar sus papeles.
It's also in Spanish.
Thank you. También está en español.
And thank you very much, interpreter.
No problem. Thank you for calling Lion Bridge for your language needs. Have a wonderful day. Bye-bye.
You too.
Bye.
Okay. And I will put the others on, I'll do the house calls right now. So, Eduardo A. Vasquez Gutierrez, date of birth January the 2nd, 2000, has a warrant out of Hacienda Justice Court, one count of theft, control of property as a misdemeanor. I am appointing counsel to represent him. He has an arraignment set on June 9th at 8:30 a.m. in a security appearance bond in the amount of $127. He has another justice warrant out of Hacienda Justice Court for one count as a criminal trespass in the third degree as a misdemeanor. Again, I'm appointing counsel since it's Justice Court. An arraignment set on June 9th at 8:30 a.m. Cash only appearance bond in the amount of $100. Number 29, Carlos Alberto Peralta. Date of birth, date of birth, December 25th, 1993. He has a warrant for violating his probation. I'm appointing counsel to represent him. Although he may have existing counsel, although I think that's a brand new petition to revoke, so therefore I'm appointing counsel. He has probation revocation hearings set on June 11th at 8:30 a.m. and setting a security appearance bond in the amount of $250. Brian Velez is a fugitive of justice case. His full name is Brian Alexis Velez. Date of birth, March 19, 2000. His warrant is for 10 counts of encouraging child sexual abuse in the first degree. He is then able to come into the courtroom because of, I believe it was suicide watch.
Yeah, dangerous.
And so The warrant actually did not have anything about the amount regarding a bond amount, just said, it didn't say anything. So, but then it stated that it looked like it was about materials. So I'm going with this, I've decided to go with, so let's go down here. So we have his name, date of birth, fugitive of justice. I cannot appoint counsel because it's civil in nature. He cannot waive his rights since he is in custody and he cannot be brought in here. So fugitive of justice hearing is set on June 16th at 1:30 p.m. So he's not choosing to waive his rights, and I'm setting a secured appearance bond in the amount of $100,000. I am including potential release restrictions just in case he somehow there's some sort of mix-up and he gets out. So he's not to initiate contact with any arresting officers, not to have any contact with any minors. And I will go and do the house calls number 3, number 7, number 29, and number 2. Number 3, 7, and 29 basically were just unable to function. Oh, and number 29 was not following orders. So that's why they were not brought into the courtroom. I will do their initial appearances at their cell. If there are any changes, I will come back and do them on the record. Otherwise, this is the 5 o'clock docket is adjourned. We're off the record. Oh. I don't know. Okay, let me just quickly again take a look at these warrants. Both these looked. Okay, this is about. Let me go back. Yeah, we can go off the record. I don't know if we're still on.
All right, thank you. Please be seated. Are we able to find an interpreter?
Interpreter on the line, Judge.
Okay, great. Thank you so much.
Spanish interpreter.
Right. I know. I had a faint hope of Mandarin, but apparently it is not to be. So give me 1 second here. Sorry, just being slow. All right, this is the 11 a.m. initial appearance calendar for June 4th, 2025.
Este es el calendario de comparecencias inicial para el 4 de junio del 2025.
The course orders for the taking of fingerprints and DNA samples made on the first calendar of the month will also apply to these hearings.
Las órdenes de muestra de ADN y huellas dactilares hechas el primer día de este mes toman efecto también para esta audiencia.
All right, I'm going to do our 2 Spanish matters at the same time.
Vamos a hacer las dos causas que necesitan el intérprete al español a la misma vez.
Let me have Mr. Flores and Mr. Angamea Islas come to the podium together, please.
Vamos a pedir al señor Flores y al señor Angamés Islas que vengan al atril juntos, por favor.
Right there. Just right there by the podium, sir.
Ahí por el atril, señor.
Here comes the other guy. Okay. All right. Beginning with you, sir, may I have your full name and date of birth, please?
Señor, ¿puede decir su nombre completo y fecha de nacimiento?
Juan Flores Jacobo, y 7 de abril de 71.
Juan Flores Jacobo, April 7, 1971.
And you, sir?
¿Y usted, señor?
Daniel Alejandro Mohameda Islas, 6 de diciembre de 92.
Daniel Alejandro Gamea Islas, December 6, 1992.
All right, thank you. Gentlemen, you have been arrested on similar allegations. I'll start with yours, Mr. Flores.
Caballeros, a ustedes se les han arrestado por alegaciones que son similares. Voy a comenzar con usted, señor Flores.
You've been accused of possessing dangerous drugs, both for sale and for personal use.
A usted se le acusa de tener drogas peligrosas tanto para la venta como para su uso.
The first one is a Class 2 felony. The second one is a Class 4 felony.
Lo primero es por un delito mayor clasificación 2 y la segunda es por un delito mayor clasificación 4.
Also, tampering with evidence, which is a Class 6 felony.
Y también por manipular pruebas, que es un delito mayor clasificación 6.
Mr. Angamea, you've been accused of possessing dangerous drugs as a Class 4 felony.
Y señora Gamea, usted se le también acusa de tenencia de drogas peligrosas, que es un delito mayor clasificación 4.
And tampering with evidence, which is a Class 6 felony.
Y manipulación de pruebas, que es un delito mayor clasificación 6.
Each of you will have your own lawyer appointed to represent you in your case.
Cada uno de ustedes va a tener un abogado a quien se le designará para representarlos en su caso.
And you have the same next 2 court dates. The first will be a status conference June 19th at 8:30 in the morning.
Y van a tener las mismas audiencias, las mismas fechas para las audiencias. La primera es una consulta de actualización el 19 de junio a las 8:30 de la mañana.
The second will be a preliminary hearing on June 23rd at 8:30 in the morning.
Y la segunda será una audiencia preliminar el 23 de junio a las 8:30 de la mañana.
The address for the court and the dates will be on your paperwork.
La dirección y la fecha para el tribunal estará en los documentos.
Based on what's been alleged against you, each of you will be released in your case on your own recognizance.
En base a las alegaciones en cada uno de sus casos, cada uno de ustedes estará libre bajo caución juratoria.
That means you must comply with your written release conditions and come to all of your court hearings.
Eso quiere decir que ustedes deben de cumplir con cada una de las medidas cautelares que se les dé por escrito y deben presentarse a cada una de sus audiencias.
Those conditions include not going back to the place you were arrested.
Dichas condiciones incluyen no regresar al lugar donde fueron arrestados,
No contact with the officers who arrested you or with one another.
no han de tener contacto con los agentes que los arrestaron o entre ustedes,
No weapons and no drugs without a valid prescription.
no tener armas ni drogas sin una receta válida.
If you miss a court date, there will be a warrant issued for your arrest.
Si no se presentan a una audiencia, se emitirá una orden para su arresto.
All right, if you please step to your left, this gentleman has your paperwork. Thank you.
Pasen a la izquierda y ahí le van a dar sus documentos. Gracias.
Thank you.
All right, and if the interpreter could make a general call, I think that might be everybody.
Yes, of course. ¿Hay alguien más en la sala que necesite al intérprete al español?
¿Al español? All right, we see no hands. Okay, thank you so much. Have a great day.
You too, Judge. Disconnect now.
Okay, bye-bye. Bye-bye. All righty. Just 1 second. I need to look something up. Are you Miss Sauer? Hi, nice to meet you. Hey, our clerk's been trying to get, is that what you have, the Form 4 for him? Oh, our clerk's been trying to get you to let you know about the Form 4. Did you?
The private attorney?
Yes.
I did just finish redacting.
Great. And so he's right there, Mr. Green, if you want to give it to him. Okay, perfect. That solves my.
I don't have it in paper, though. I emailed it. I received
Oh.
email. I'll print it out right now.
Okay, thanks. All right, so we're going to hold off on doing that case. If you want to have a seat, I'll just let him know. Hi, Mr. Green. I guess you just emailed the redacted Form 4, and my clerk's printing it out.
Perfect.
Okay. And then when you're ready, I'm ready, so take your time, though. I have a whole calendar today, so. Right. Obviously, time is money for you, but when you're ready. Okay, all right, thank you. Ms. Aldabat, Yannette Aldabat, will you please come to the podium? And then Amy Porter, if you'll go to the chair, you'll be after her. All right. Hello, ma'am. Can I have your full name and your date of birth, please?
Yannette Aldabat Contreras, 7/6/1995.
All right, thank you. You're on 3 things. 1 is a grand jury warrant in a newly charged case, and 2 are probation warrants. I'm going to start with a grand jury warrant. You have been indicted by a grand jury on the following felonies: identity theft, a class 4 felony, 2 counts of that, 3 counts of false reporting to law enforcement. Those are all class 1 misdemeanors. The alleged offense dates in the indictment range from December 4th of 2022 to June 27th of 2024. The grand jury found probable cause for those. I am appointing a lawyer to represent you. Your next court date in this grand jury case will be June 11th at 8:30 in the morning. That's 1 week from today in the downtown Superior Court, and the address will be on your paperwork. There were probation warrants out for you in both of your probation cases because petitions to revoke your probation were filed on November 19th of last year. They allege that you violated terms 3, 4, and 5. You'll get copies of those petitions from your lawyer. I'm also appointing a lawyer for you in the probation cases. You have the same next court date for your probation cases. It is June 11th at 8:30 in the morning, which is 1 week from today. And in the probation cases, that will be what is called a revocation arraignment and possible disposition hearing. In the grand jury case, I am affirming the bond set out of the grand jury proceeding, which is $15,000 secured. In each of your 2 probation cases, your bond is $5,000 secured. That is $25,000 total. If you bond out, comply with all of your written release conditions, particularly don't go to the scenes of the crimes in the new case, no contact with the alleged victim, who is the court's understanding is your sister, no contact with her. You may not respond to any contact from her. Everything you need to know is on your paperwork. If you step to your left, the officer is going to give you copies. Thank you. Why does my computer keep doing that? Is it mine or is it yours? I think it's something. Let me see if I can just silence this. Notifications or something. I don't know why that is happening. Okay. Well, I turned on a do not disturb, so maybe that'll work. All right. After Mr. Porter, it'll be Kirk Ashley. Thank you. All right, ma'am. Can I have your full name and your date of birth, please?
Amy Frame Porter, 12/13/78.
All right, thank you. You're here on a new case. The police came and added charges to your booking. They are accusing you of third-degree burglary, a Class 4 felony, theft by control of a stolen credit card, a Class 5 felony, and fraudulent use of a credit card, a Class 6 felony. The alleged offense date for all of these is January 10th of 2025. Let me double-check that.
Yes.
And there is probably, yes, it was January 10th. There is probable cause for all of those. So I am appointing a lawyer to represent you. You're going to end up with the same lawyer for this case that you have for your other pending felony case. And it looks like
Your Honor, can I
you have yet, just one second.
Okay.
You have yet another direct complaint pending. Looks like that was a summons case. So unfortunately, I can't see you on that. There's no warrant out for that, but I want to let you know there's a third case coming. You may or may not have been aware of that. I'm unable to handle that for you, though, because right now, I think it went out as a summons. So the court date is tomorrow. No warrant has been issued. A warrant will be issued tomorrow, assuming you're still in custody, because the sheriffs won't take you there if you're not legally held in that case. So I'm appointing a lawyer for you. Your lawyer will help you with all of that. Your status conference in this new case is June 10th, which is 6 days from now, at 8:30 in the morning in the downtown Superior Court. That's a status conference. Your preliminary hearing will be June 12th at 8:30 in the morning. What did you want to tell me?
I just wanted to let the court know that I have the bond project that was trying to bond me out on my original bond that was posted of $5,000, which was really high for one charge. But it took me a month to get them to do this. I have like major support. I have a steady home to go to. Like my whole family's been fighting to get me out, and they were supposed to post a bond like yesterday. So please, can you?
All right, ma'am. I'm going to note just 1 second though, and I want to give the state a chance to weigh in if they want to. Counsel, you filed a recommendation requesting a no bond hold, but when I look at the docket for 077, that says her IA, that's the case number ending in 077, which is the one you list. She never saw a judge in that case until May 8th. So she was not on release in that case until May 8th.
Never.
And ma'am, I'm not talking to you. The court date, the offense date in the new allegations is January 10, a full 4 months before she was on release in 077. If you want to be heard on that, you can, but you are not on release in a case until you have received release conditions from a judge. So, am I missing something?
It's possible. I just didn't notice that the dates were in the
Okay, all right, no worries.
order.
Okay, all right, then.
Discussion.
All right, then, Ms. Porter, I do find that you are eligible for bail in this case. I am not persuaded that bail is not warranted in your case. You have a very, very long criminal history. You have multiple pending cases. You have a criminal history for this exact type of offense, and I show that your most recent criminal conviction was aggravated identity theft, for which you served 3.5 years in the Department of Corrections. So the court believes that community safety requires a bail in your case, that it is, you pose a very high risk of reoffending, notwithstanding the bail project's interest in you, ma'am, and the court does not, I don't give that any weight one direction or the other. I don't think it favors you. I don't think I'm not trying to weigh it against you. This court believes it simply does not move the needle on the probability that you're going to commit offenses or that you're going to fail to appear when you have so very many felony convictions and you're going to have a third open felony case. So this court believes that unsecured release is not appropriate. Bond is set in your case at $5,000. It is secured with release conditions that include no victim contact in this case. You can say one more thing, but then I do have to move on.
Okay. Your Honor, I'm SMI. My mental health provider has also been in contact with the bail project. They're all working together to get me out because I do have a stable residence. Please, they will still bond me out if my bond is like $7,500. Can you please?
No, ma'am, the court, for the reasons I previously stated, which do include a very long, a 20-year felony criminal history, this court believes that unsecured release or a lower bond amount is not appropriate. If you please step to your left, the officer's going to give you a copy of your paperwork. Good luck, ma'am. Mr. Ashley, Kirk Ashley. Good morning, sir. Can I have your full name and your date of birth, please?
Roy Ashley, June 28th, 1969.
All right, thank you, Mr. Ashley. You're here on a new case, a misdemeanor warrant, pardon me, and a probation hold. In your new case, you were arrested for evidence tampering, a Class 6 felony, and endangerment, a Class 1 misdemeanor. There is probable cause for both of those, and I am appointing a lawyer for you. It'll be the same lawyer that you have for your probation case. The probation department will be filing a petition to revoke your probation. You are on probation for a Class 2 felony. So your next court date will be the same for both of these felony cases. No, I apologize, it's slightly different right now. Eventually, the court dates will come together in the system. In the new case from yesterday, your status conference is June 10th, 8:30 in the morning. The next day, June 11th at 8:30, you'll go to probation court for your revocation arraignment hearing. Finally, on June 12th, you'll have a preliminary hearing in the new case only. Now, in the city court case, this is from the town of Wickenburg. They have put out a warrant for you in a case in which you've been charged with drug paraphernalia, possession of Class 1 misdemeanor. They also have added an allegation of failing to appear in a misdemeanor case, which is itself a Class 2 misdemeanor. I am appointing a lawyer for you in that case just because I'm giving you a small bond. This warrant was issued while you were in DOC, but I'm about to give you bond in your felony cases, so I don't want you to miss any court dates in Wickenburg. The court date I have for you there is June 11th at 9 in the morning. I'm setting a $50 placeholder bond just to make you eligible for credit. Wickenburg's probably going to have to move their court date, though, because I also just gave you felony dates on June 11th. All right, your bond in the brand new case is $2,500 secured, same amount in your probation case. So you have a $5,000 total secured bond with written conditions. If you bond out, call your PO within 72 hours. This gentleman has a copy of your paperwork. Good luck, sir. Mr. Richardson. I need Michael Richardson, please. After that will be Francella Ferracci. After Mr. Richardson, or Ms. Ferracci, if you're ready and Richardson's asleep, I'll take whoever's awake. All right, you can go ahead and come in, ma'am. Let's have Mr. Richardson have a seat. No, you go ahead and come in, ma'am. He can wake up for a second. Hi, ma'am. Can I have your full name and date of birth?
Hello.
No, have him sit, sir. Sir, you were asleep. You missed a lot. Have a seat, okay?
Good afternoon. It's Francella Mungar, May 27, 1976.
Okay, will you tell me your name one more time, please?
Francella Mungar, May 27, 1976.
How do you spell your last name?
Mengar.
Okay, so that's your last name. What is Ferracci or Ferracci?
That's an old last name.
Okay. All right. All right. I've put that into our system here. Just so you know, ma'am, you will likely need to update that downtown because our computers no longer talk to the downtown computer. So be sure your lawyer gets your name straightened out on the record downtown. Okay. All right. You have been arrested on one allegation of aggravated assault with a deadly weapon or dangerous instrument. It is a Class 3 felony, and there is probable cause for it. I am appointing a lawyer to represent you. Your next court date will be a status conference June 10th, which is 6 days from now at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be June 12th at 8:30 in the same court. Based on what's been alleged against you, I find the state's recommendation is appropriate. I'm setting bail in the amount of $2,500. It is secured. If you post it, you'll be ordered not to go to the scene of the alleged crime. Whether you're in or out of custody, you will not have any contact with the alleged victim. No weapons, no drugs, no alcohol. Everything you need to know is on your paperwork. If you step to your left, the officer has a copy. Good luck, ma'am. All right, now, Mr. Richardson, I'm ready for you, sir. And then Ayana Moreno, if you please go to the chair. All right. Hello, sir. May I have your full name and your date of birth, please?
Michael Richardson, 10/17, 1989.
Okay, thanks. You are here on 2 probation warrants. You're on probation in 2 different felony cases. There were petitions to revoke your probation filed on January 14th of 2024. The petitions allege that you violated terms 3 and 5 of your intensive probation. You'll get a copy of those from your lawyer, and I am appointing a lawyer for you. Your next court date will be June 11th at 8:30 in the morning in the downtown probation court. That's going to be a revocation arraignment and possible disposition hearing. In the Class 4 felony case, your bond is $3,000 secured. In the I think they're both a Class 4. One's a drug case. Let me do it this way. In the 2020 case, the older one, your bond is $3,000 secured. In the 2023 case, it is $1,000 secured. That is $4,000 total. If you bond out, comply with all of your written conditions. You have to call your PO within 24 hours of release because you are on IPS. The information is right there on your paperwork. If you step to your left, they'll give you that. Thank you. Ms. Moreno, Ayana Moreno. And then Chad Smith, we go to the chair. Good morning, ma'am. May I have your full name and your date of birth, please?
Ayana Lisa Moreno, 11/14/2000.
Okay, thank you. You're hearing a warrant from the Pima Consolidated Justice Court down in Tucson, and that court issued a warrant for you on December 30th of last year. It is a failure to appear warrant in a pending felony shoplift case. I'm going to let them know they should appoint a lawyer for you when you get there. Your next court date is an arraignment hearing in the Pima Consolidated Justice Court this Monday, June 9th, which is 5 days from now, 8:30 in the morning in that court, and the address in Tucson will be on your paperwork. I'm affirming the bond set by that court. It is $2,499 cash only with written conditions you're ordered to comply with, including no returning to the scene of the alleged crime in the underlying shoplifting case, no contact with any alleged victims. Everything's going to be on your paperwork. If you step to your left, I'll give you a copy of that.
I have a question.
Go ahead.
So my name was getting used, with somebody was using it for the discharge and for taxes. So how do I go about that?
Well, identity is a defense in a criminal case. What we know right now today in this court is that your fingerprints appear to match the person against whom this warrant was issued. As to whether you are the person who committed the crime, that is literally the subject of your trial. So talk to your lawyer about an identity defense. This court is unable to determine whether you are the person who committed the crime. Again, that's why you get a trial. So talk to your lawyer about trying to prove that this was not you at all. As far as whether this warrant is attached to your name and fingerprint record in the state and or national system, it is. So you'll have to post this bond, you get out of custody or not. You'll have a lawyer down there. You talk to your lawyer about asserting that defense. If you step your left, go ahead.
So I'm the sole provider of I have 2 kids. And I just moved, well, I didn't just move out here, but they don't have nobody to
All right, then you need to call DCS from the tank. You have a legal obligation to see to their protection. If you think that they are in danger of any type of abuse or neglect, you could literally be prosecuted if you fail to call DCS.
Okay.
They will take a collect call from back in the tank. Good luck, man. Mr. Smith, Chad Smith. If that Justin Crudup, will you please go to the chair? Hi, sir. Can I have your full name and date of birth?
Chad Smith, 215-1978.
Thank you, Mr. Smith. You are here on 3 probation warrants. And in each of your probation cases, there were petitions to revoke filed on May 30th of this year. They allege that you violated terms 3 and 5. You will get a copy of those from your lawyer, and I am appointing a lawyer for you. Your next court date will be the same for all 3 cases. It's 1 week from today, which is June 11th at 8:30 in the morning in the downtown probation court. That will be a revocation arraignment and possible disposition hearing. I'm affirming the bonds that the probation judge gave you. In number 29 on the calendar, that's the 2022 case. Your bond is $2,500 secured. In each of the other cases, pardon me, it is $250 secured. So that is $3,000 total. If you bond out, be sure to comply with all of your written conditions. Call your PO as soon as you get out. The number is on your paperwork. If you step to your left, he'll give you a copy of that. Thank you. Mr. Crudup. And then Gigi Escobar, will you go to the chair? Hello, sir. May I have your full name and your date of birth, please?
Justin Lamar Crudup, 07/15/1993.
Okay, thanks. Mr. Crudup, you're here on a new case and 2 probation holds. In the new case, you were arrested for possession of a weapon by a prohibited person. It is a Class 4 felony, and there is probable cause for it. I'm going to give you a status conference in that case of June 10th, which is 6 days from now at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing June 12th at 8:30 in the same court. In the probation cases, the probation department will be filing a petition to revoke your probation between now and your next court date. You'll get a copy of that petition from your lawyer at your next court date. And you should end up with the same lawyer for all of these cases. Your next court date in the probation cases is June 11th, 1 week from today at 8:30 in the morning for a revocation arraignment and possible disposition hearing. The address in the downtown Superior Court is on your paperwork. On these facts, bond is set in each of your probation cases at $750 secured, that's $1,500. In the new case, the court is setting what is called a placeholder bond. It is $50 secured with written conditions, so that is $1,550 total. If you bond out, comply with all of your conditions, do not fail to call your PO when you get out. The number is on your paperwork. If you step to your left, you get a copy of that. Thank you. Ms. Escobar, Gigi Escobar. And then Marcia Turner, we go to the chair. Hello, ma'am. Can I have your full name and your date of birth, please?
Gigi Escobar, 31095.
Thank you. You're here on a warrant in a pending case. You've been charged with narcotic drug possession. It's a Class 4 felony. You failed to appear at a post-warrant status conference on April 24th of 2024, and another warrant was issued for your arrest. You already have a lawyer in this case. Your next court date will be a post-warrant status conference this coming Monday, June 9th, 8:30 in the morning in the downtown Superior Court. Despite the passage of time in your case, I'm just going to affirm the bond that was originally set for you. It is $500 secured, and that is because based on your criminal history, it is entirely possible that the county attorney will still make you a diversion offer at the next hearing, meaning you could ultimately go into a diversion program if you successfully complete it. You never take a conviction in this case. Also, if your criminal history is what I think it is, this is probably a probation mandatory case. So dodging court repeatedly is frankly stupid.
Yes,
if you do it again, you're going to lose the $500, the bond money will go up, and then the odds of getting a diversion offer from the county attorney start going down. I'm telling you these things because I want you to get a clue. This is second failure to appear in this case. I am imposing the $500, but this warrant went out more than a year ago. Typically, I would double the bond because of that. I'm not doing it because I'm trying to give you a clue. Go to court.
Yes, ma'am.
Everything you need to know is on your paperwork. If you don't, and if you are addicted to what you're likely addicted to, we will see you again. You're not going to dodge the police very long.
Yes,
so
ma'am.
use your brain. Don't lose your paperwork. Go to court.
Yes,
it's a simple equation. You're not likely to go to prison on this case.
I don't have no funds.
You don't have.
I don't have no funds.
Then you stay in jail until next week. You can't do it twice, ma'am. You did it twice.
Okay.
That last hearing was because you missed court. So the court doesn't trust you. So if you don't post bond, they take you to court next week. You talk to your lawyer. Your lawyer will help you get the best outcome that you can, including going to trial if that's what you want to do. Good luck, ma'am. Ms. Turner, Marcia Turner, and then Miguel Trujillo, will you go to the chair? Hello, ma'am. Can I have your full name and your date of birth, please?
Marie Turner.
Which date of birth, ma'am?
11/15/79.
All right, thank you. You're here on a probation warrant. You are on probation for a Class 6 felony, and there was a petition to revoke your probation filed on April 21st of this year. That petition alleges that you violated terms 3 and 5. You'll get a copy of it from your lawyer. I am appointing a lawyer for you in probation court. Your court date there is 1 week from today, which is June 11th at 8:30 in the morning. It's a revocation, arraignment, and possible disposition hearing. The court address is on your paperwork. I'm affirming the bond that the probation judge gave you. It is $450 secured. If you post it, comply with your conditions and call your PO as soon as you get out. Don't miss your court dates. He's got your paperwork for you. Mr. Trujillo, and then Caleb Aguirre, will you please go to the chair? Hello, sir. Can I have your full name and your date of birth, please?
Miguel Trujillo, 1999.
Okay, thanks. You're here on a probation warrant. You're on probation for a Class 6 felony, and on May 12th, there was a petition to revoke your probation filed. It alleges that you violated terms 3 and 5. You'll get a copy of it from your lawyer, and I am appointing a lawyer for you. Your court date is in the downtown probation court 1 week from today, which is June 11th at 8:30 in the morning. It's a revocation, arraignment, and possible disposition hearing. Your bond is $250. It is secured. If you post it, comply with all of your written conditions and don't miss your court dates. Call your PO when you get out. If you step to your left, we'll give you paperwork. All right, Mr. Aguirre, and then Quenisha Fisher, will you please go to the chair? Hello, sir. May I have your full name and your date of birth?
Caleb Ajay, 08/16/2001.
Okay, thanks. You're here on a new case. You were arrested for aggravated assault on a person summoned to assist a police officer. It's a Class 6 felony. There is probable cause for it, and I am appointing a lawyer to represent you in this case. Your next court date is a status conference June 19th, which is 2 weeks from now, 8:30 in the morning in the downtown Superior Court, with a preliminary hearing June 23rd at 8:30 in the same court. You have very little, if any, criminal history. So I'm going to release you to pretrial services. The court doesn't set bail based on how much it might dislike what someone has been accused of. What you've been accused of is something that I don't find makes you a possible menace to society or likely to fail to show up for court. If you don't show up for court, you're going to get a warrant issued for your arrest. I'll note the state did request a $1,500 bond for you. I'm not making you post that bond. I am making you report into pretrial services. You are not to go to that Banner Thunderbird Hospital, not voluntarily. If somebody transports you there, you can't help it. But you don't go there. Okay. You don't initiate any contact with that security guard. Okay. Everything you need to know is on your paperwork. Will you come to court and comply with your conditions?
Yes, yes.
Okay, then you are released. Don't lose the envelope. It tells you where to call.
Address and everything?
And yes, everything's on your paperwork. The envelope tells you where to call pretrial when you get out. You need to call pretrial after you get out, okay?
But, so how long do I have to I call pretrial?
We don't make a specific order. I think it's in the paperwork. I think they give you 3 days, but I haven't read that paperwork in a long time. The instructions are in the paperwork. It's not hard. You'll have plenty of time. It's not. Just make sure you do it if you do it within a day of getting out, you're good.
Okay.
Don't miss your court date. All right, thank you. All right, Mr. Green, you want to go ahead and let's do yours? Okay.
Absolutely. Thank you.
All right, Ms. Gonzalez, can I have your full name and your date of birth, please?
Trinity Marie Gonzalez, 10/16/2002.
Thank you. And then the appearance of the state, please?
John Sauer on behalf of the state.
Thank you, and the defense.
Good morning, Honor Lincoln Green, on behalf of Ms. Gonzalez.
All right, thank you very much. Ms. Gonzalez, you have been arrested on a new case. The allegations are burglary, it's just one, burglary in the second degree, a Class 6 felony, alleged to have occurred April 26th of 2025. And before I talk about release conditions, Counsel Green, I am inclined to find probable cause based on what the police have submitted. Did you want to be heard on that, or are you ready for the court to just rule on what I have?
You can rule on that, yeah.
Okay, thanks. Then I do find, based on what the police have submitted, ma'am, that a probable cause has been shown. As your lawyer will tell you, that's a long way from beyond a reasonable doubt, but they have met the standard for probable cause. So I do find probable cause for that allegation. And let me hear the state's recommendation on or orders for release or conditions, and then I'll turn to the defense. Go ahead, Ms. Sauer.
Your Honor, the state believes the defendant is non-bondable because she's on felony release in CR 2024-125476.
All right, Mr. Green.
Well, Judge, I'm very much aware. My client was set for sentencing on the 19th of this month, so I'm aware she was on release for this. We've got some extenuating circumstances here, though. Her father just passed, and there's a burial date set for the 14th of June. This is horrible timing. I understand this event is alleged to happen late April, but apparently my client's father, who passed, made her the administrator of his estate, and so an executor, I should say, and so she's had to set up all the proceedings, and so that's tough with her not being there. She also has a couple kids that she's gonna have to make arrangements for. We did notice in the Form 4 that there was a request by the Sheriff's Department for a $50,000 bond, and I understand, I'm very much aware of the law. I would ask the court to consider holding in advance a finding of non-bondability based upon the fact that I'd like to have a bail eligibility hearing, presumption evidence,
Proof evidence, presumption grade.
Yeah, exactly. I'd like to try to have that hearing, and I'm really trying to get to the point where I can get her to at least attend the funeral, unfortunately, for her. I would ask the court to consider holding off a finding of non-bondability impose a nominal bond, and allow her to be released on a bracelet.
All right, thank you. Ms. Gonzalez, I've considered what's been alleged against you and the statements of both of the lawyers here in court today and your criminal history. And on these facts, the court believes that the finding of probable cause is self-evident. There is probable cause for this. The ankle monitor is a strong piece of evidence, and the court cannot, will not disregard it. Also, the law says shall, and it is something that derives from the Arizona Constitution. This court does not believe that it has the discretion to deviate from that, nor would the court be inclined to, even on these facts, which are not unsympathetic. There is never a good time to be arrested and jailed for a felony. But on these facts, and considering the implication that a person who is awaiting sentencing in a very serious case committed a serious crime, a serious felony, the court would not be inclined to grant it even if it were discretionary. But what I can do is give you court dates that are in advance of your father's funeral. So your status conference is going to be June 10th at 8:30 in the morning. As Mr. Green is well aware, that is an opportunity to speak to the assigned prosecutor and perhaps go a different route than a bail hearing the next day. But I do have to set your bail hearing. That's going to be an evidentiary hearing, June 11th at 1:30 in the afternoon. I'm sure Mr. Green explained to you what goes on there, but if that bail hearing goes forward, he will be there to represent you. And Mr. Green, did you notice him for the whole case?
I did, Your Honor.
I thought so. Okay, okay. So, because I'm not appointing a lawyer for you, ma'am. All right, your preliminary hearing is currently set for June 12th at 8:30 in the morning. But, and I've never worked in that bail eligibility court, it is my understanding, many things happen, many things are possible, and if anybody knows, it's going to be Mr. Green. So, good luck on the 10th. I am sorry for your loss. I'm not unsympathetic. It's just in terms of what the things that the court has to weigh, that is what the court believes is the best and only decision for today. All right, thank you very much. If you want to keep using the room, you're welcome to. We'll print you a copy. And Ms. Starr, if you wanted to be excused, you can also go or stick around and spectate. All right, Ms. Fisher? And he'll let, or I think you might be able to badge out if you want. Okay, usually what I try to do is I hold the defendants out the door while you go.
All right,
So,
thank
okay.
you.
All right, thank you. See you soon.
That's why I came.
Okay. Okay, all righty, ma'am. And then I need Ms. Perowitz-Bowen if you go to the chair. Hi, ma'am. Can I have your full name and date of birth?
Commissioner Fisher, 7593.
Okay, thanks. You are here on a new case. You got arrested for resisting arrest, a Class 6 felony, and failure to obey a police officer, a Class 2 misdemeanor. There is probable cause for those, and I am appointing a lawyer for you. Your next court date is a status conference, June 19th at 8:30 in the morning, with a preliminary hearing June 23rd at 8:30. And I've considered your risk assessment score and your criminal history. And you might be surprised to know that I am going to release you to pretrial services. You do have a history of this type of offense. You do. But what they're alleging against you, this court believes, well, it doesn't inherently imply that you are a public safety risk or that you're not going to come to court. It does not inherently imply that. And that you may be smart enough to come and talk to your lawyer and defend this case. Because with your history, you could actually face prison time if you were convicted in a case like this. Doesn't mean I think that you should, but you could. So you need to be smart and come to court. If you prove you won't come to court by missing a court date, you're going to end up with a bond. The state asked for a $1,500 bond in your case, but on these facts, which basically started with jaywalking, I am prepared to give you a chance to come to court on your own and be out of custody and deal with this case. So, will you comply with your release conditions and come to court?
Yeah.
Okay, then you are released. Everything you need to know is going to be on your paperwork. There's an envelope for pretrial services. I'd say within a day of release, be sure to call that number. They're going to tell you how they want you to check in. It's usually by telephone. Sometimes it's in person, but they do their own assessment. You just have to do whatever they instruct you as far as checking in with them. It's not typically very hard. Don't miss your court dates. They're both on your paperwork, okay? It's going to be, did I say it already? June 19th at 8:30 for a status conference, June 23rd at 8:30 for a preliminary hearing. All right, good luck, ma'am. He's got your paperwork. My staff is attempting to track down a Mandarin interpreter, so whoever I may have called, as soon as we get a Mandarin interpreter, we're taking a break in that case and going to the interpreter. And Let's see, I have Ms. Perowitz, okay, and then Juan Arriaga, will you please go to the chair? Hi, ma'am, can I have your full name and date of birth, please?
Jennifer Day, Perowitz Bowen, August 29th, 1983.
All right, thanks. You're on a new case. You got arrested for narcotic drug possession, a Class 4 felony, and shoplifting as a Class 1 misdemeanor. There is probable cause for those, and I am appointing a lawyer to represent you. You have 2 upcoming court dates, and that is going to be a status conference June 19th at 8:30. That's about 2 weeks from now, and a preliminary hearing June 23rd at 8:30. And the state recommended that you go to pretrial services with drug testing. I know why, because of these allegations and your criminal history. But on this type of case, frankly, I have a pretty good idea what the drug testing would reveal. I just want you to come to court. So I'm going to follow the recommendation to release you. Be smart, just like I told the other people. You got one of those kinds of cases where it could go either way. You know, if they, think you're a terrible candidate for probation and the state doesn't offer it, if you lose at trial, you could actually face prison. But if the state wants to offer you a probation, which in this type of case is basically drug possession, you've got the shoplifting as well, but in this type of case, the state is sometimes still offering probation. You won't know that if you don't go to court. And if you don't go to court, you'll prove we should give you a bond next time. So don't. Just show up. Stay away from this store. It was the Circle K. Don't go there. No contact with their employees. Don't miss your court dates, okay? Everything's on your paperwork. If you grab that on your way out.
Thank you.
Good luck, ma'am.
Thank you.
We do? Okay, we have an interpreter. Everybody stop, and let's get Ms. Yue Hong. And then if the officer can close the door, they'll kill the echo for the interpreter. Okay, thank you. All right, can the interpreter hear me?
Yes, Your Honor, yes.
Okay, thank you so much. The defendant is here in court with me, so I'll get started. All right, ma'am, please wait until the interpreter is done translating and then tell me your full name and date of birth.
你好，我是你的中文翻译员等待这个翻译员问完之后再由你提供一下你的姓名还有你的生日给这位法官，谢谢。
好的，谢谢。
Understood, thank you.
All right, go ahead, ma'am, with your name and date of birth.
请你提供一下你的姓名还有你的生日。
我的姓名叫于月红，我的出生年月日是5月17日，1970年。
于月红是吗？姓洪是吗？还是姓于？
姓于。
姓洪。
不，姓于，于月红。对的。
Okay, Your Honor, the defendant's name is Ye Hong Yi, and date of birth May 17, 1970.
All right, thank you very much, ma'am. You are here because you have been arrested on a criminal warrant.
那谢谢你，这位女士，你现在被逮捕你现在到今天出院就是被逮捕，有个拘捕要逮捕你，所以你今天出庭就是因为你被逮捕，谢谢。
There are 3 charges. The first one is money laundering, a Class 2 felony.
总共有3个罪那个罪项。第一个就是那个洗钱这是等于是2等的这个重罪，谢谢。
Also, conducting an illegal business enterprise, which is a Class 3 felony.
然后另外一个就是你在从事这个非法这个活动非法的这些交易，所以这等于是第3级的这个重罪，谢谢。
And finally, one charge of operating a house of prostitution, which is a Class 5 felony.
Thank you, Honor. 另外一个就是你从事这个色情行业那个就是妓女那个就是妓女那个人体肉买卖这样子的这个性交易这个是一个第5级的这个罪行，谢谢。
And you are accused of committing these offenses in 2023.
Oh, I'm sorry, Your Honor. Can you repeat that again? What was she accused
Sure.
of in 2023? Thank you. Yes, ma'am.
You are accused of committing these crimes in 2023.
Thank you. Thank you, Your Honor. 这些罪呢，被起诉的这些那个案例，就是2023年就被起诉了。谢谢。
You have the right to be represented by a lawyer in this case.
你有权利可以请一个这个代表律师来代表你谢谢。
But you would have to hire one because you do not financially qualify for a free court-appointed lawyer.
Thank you, Your Honor. 你自己要去那个聘请一位律师，因为你这个经济上呢没有资格符合由这个法院来提供一位免费的这个辩护律师。谢谢。
Your next court date will be June 11th at 8:30 in the morning at the address in downtown Phoenix that is on your paperwork.
Okay, thank you, Your Honor. 下一个出庭日期是6月11号早上8点半，在这个就是说Phoenix 凤凰城这个地址呢会在你的这一些相关的这一些证件文件法院给你的文件里面有备注这个出庭的日期跟出庭的这个地址谢谢。
You have a bond in this case, which is money deposited with the court to guarantee you will appear at all of your court hearings during the case.
你可以就是那个交保就是跟法院交保保证未来有任何出庭需要你出庭的时候，你都会亲自本人到法院去出庭，谢谢。
And if you do appear at all of those hearings, you are entitled to ask the court to return that money to you at the end of the case, even if you are convicted.
然后呢只要你每次出庭呢都准时出庭不会那个缺失的话，到整个案件判完结果，不管你是不是被判有罪还是有什么样的结果，这一笔保释金可以要求法院退回。
The amount of that bond is $10,000.
你的保释金也就是$10,000。
And you may use the services of a bond company in order to possibly deposit that money for less than the full amount.
你可以请用那个就是说请一家这个保释公司那个来帮你交保然后把这个钱直接存入他们的这个法院账户，谢谢。
The sheriffs have a list of those companies back in the cells, and you can use a phone to call them from the jail if you want to.
这个当地的这个警察官警察人员到时候你回到监狱去的时候，会由他们提供一系列的这个保释那个公司的电话给你，你可以从这个就是说监狱里面打电话来跟他们联系。
Whether you are in or out of jail, you may not have any contact with any co-defendants in your case.
不管你是否在监狱还是在外面，你不允许你跟任何你的其他的共犯有任何的联系。
No contact with any of the witnesses or the arresting officers.
你也不能跟任何的目击证人联系，也不能跟 拘捕你的、逮捕你的那些警员警察有任何的沟通、任何的联络。
If you are out of custody, you may not go to the scene of the alleged crimes.
你一旦就是说被那个没有被拘捕在外的话，也不能再回到你之前犯案的这一些场所地点。
You may not possess any weapons.
身上不能持有任何的武器。
You may not leave the state of Arizona without the advance permission of the court.
然后呢，你也不能离开这个亚利桑那州，没有法院同意你离开，你不能擅自自己离开这个亚利桑那州。
Your complete orders are in writing. If you'll step to your left, the officer has your copy. Thank you.
然后呢，今天那个就是说跟你所说的一切都有一份总结记载。旁边这位警官他有一份给你然后保留需要你签字。
我想问一下，如果我不能跟外界联系的话，我怎么能联系朋友？因为我这边没有别的亲人，也没有别的人，我找别人帮我交保释金，我怎么样的跟别人联系呢
？Your Honor, the defendant is stating that how could she or how can she get a hold of someone? She does not have any family or friends here in where she's at right now. As far as asking for assistance or her to have someone else post the bail bond for her. How does she go about contacting anyone since she doesn't happen to have any family members or friends, relatives? Thank you.
The court is unable to help you with that. However, if you call a bail bond company, they may be willing to try to help you locate family or friends who could post the bail for you.
Thank you, Your Honor. 法院帮不了你他们就是会给你一系列的，刚才有告诉你回到监狱那个就是警官警察人员会给你一份就是一系列的这个保释公司然后由你跟保释公司提供你朋友、家人、亲戚的电话号码，由保释公司的人员跟你的家人、亲戚、朋友联系，看看谁能帮你交保释，好吗？谢谢。
And you will be back in court on June 11th at 8:30 in the morning. If you are still in custody, you could ask the court to reconsider whether to appoint you a lawyer at that time.
然后请你在6月11号早上8点半要再回到这个高等法院凤凰城的这个高等法院，到时候你可以跟这个法官说是否由他们可以同意帮你请一位所谓的这个法庭提供给你的免费律师辩护律师。
Good luck, man.
我还有一个问题我想问一下，那么我提供一些证据证明我无罪的证据是我可以提供吗？是让我回去提供在6月11号的时候。
Your Honor, the defendant is asking you that when on her next court appearance on June 11th, is she allowed to obtain and gather some evidence and proof of her innocence to prove that she is innocent? Thank you.
The next court hearing is not your trial.
Okay. 下一个6月11号。Oh, I'm sorry, Your Honor. Go ahead.
No, please go ahead. I was waiting for you. You were waiting for me. Go ahead.
Thank you, Your Honor. 6月11号，也就不是说正式的那个听证会啊出庭，好吗？就是会出庭，可不是正式的，就是说来开始进入来审判。Yes， 你的罪行啊。
But at that hearing, they will give you some more future court dates.
Thank you, Your Honor. 6月11号出庭之后，法院法官会再给你一些要出庭的那个日期讯息。
So the next hearing is procedural. They do not take evidence at that type of hearing.
下一个那个6月11号是一个就是说正常的那个听就是说进入下一个阶段下一个要出庭的这个步骤的这些信息，所以在这一个下次的6月11号出庭呢就是说他们不会要求，也不会就是说要你提供什么样的这个说你是无辜的这些证据说明证明下一次6月11号用不到。
Okay, one more.
Okay. 我今天如果联系到朋友帮我交保释金，是不是今天就能出去，还是要等到哪一天呢
？Your Honor, if she's able to, get someone, maybe a friend or a family member to post bail for her today, or will she be released today, or would it be tomorrow?
You are released usually within a few hours of the sheriff's office receiving the money.
一旦这个警官呢他们那个警官单位有收到你的这个朋友帮你交保的表示金，几个小时后你应该就可以离开这个监狱，好吗？谢谢。
好，谢谢。Okay.
And be sure not to miss your court dates. It's on the paperwork.
Okay.
记得在这个纸上呢这个纸张上面有要出庭的日期千万不要不出庭好吗？千万不要那个就是说不出庭一定要出庭。
Okay. All right. Okay. Thank you so much to the interpreter. We're all done. That was great. Thank you.
Thank you very much, Your Honor. Thank you. Have a great day, man. Bye-bye.
You too, sir. All right. Mr. Arriaga, and then after that, Mr. Singh, if you go to the chair. Hi, sir. May I have your full name and your date of birth, please?
Valentin Arriaga, February 14, 1992.
Okay, thanks. You're in a new case. You got arrested for resisting arrest passively, which is a Class 1 misdemeanor, and failing to obey a police officer, which is a Class 2 misdemeanor. There is probable cause for those. I'm not appointing a lawyer for you because I'm going to release you in this case to come to court on your own. And we don't give you a lawyer in this type of case unless you're stuck in on a bond. Are you stuck in on something else?
No, I want to bring something up.
Okay, not yet. Hold on. So your court date is going to be June 20th at 10 in the morning in the Moon Valley Justice Court, and the address is going to be on your paperwork. As I said, I am willing to release you, provided you agree to come to court and comply with your release conditions. Will you do that?
Yes, ma'am.
All right. And what did you want to say?
So regarding my booking papers, me and my co-defendant, my brother, we got arrested together, and it seems like all my credit cards, all my wallet and stuff, my phone, was put into his.
Oh no!
And so, and so when I figured this out, I told them, and they said there was nothing they could do about it.
Well, and so so when you go to get released, they're going to bring the bag of your stuff. Let me see what happened to him. Do you remember? I remember him on here, but I don't remember what happened.
That's another thing too I wanted to bring up because
He ended up a house call. Just 1 second. Is he a house call just because his brother's in here, or was he allegedly misbehaving back in custody?
No.
Oh, this says combative. Just 1 second, sir. It says combative. Okay. So I have to go see your brother after this. Because your brother's on probation, I am intending to give him a bail. So the issue may be that I don't know, I have no orders I can or will make that will help you with that. Just in terms of advice, you're going to talk to, hopefully, the property person when you're getting released. They could maybe direct you to where you could go downtown to the sheriff's office and file a form to say my property has been impounded as his. But if it's stuff that clearly has your name on it, Juan versus Jason, maybe they'll consider doing it. All I can tell you is also talk to the. I'm not giving you a lawyer. I'm sorry, I can't. Not on this type of case.
Okay.
You're kind of on your own for that, and administratively, that could be a little hairy. I'm not unsympathetic, but this court, will not conduct a hearing to order the sheriff's office to give you specific things. That can happen in the Moon Valley Justice Court at a later court hearing. This is just a limited type of proceeding, and we do not issue that kind of order against the sheriff's office. They don't have a lawyer here. They don't have anybody here to represent them. So I believe you that could have happened. And I'm sorry if that's the case. All I can tell you is good luck trying to deal with the property bureau at sheriff's as you and after you get released. So.
Okay. And one more thing, since you bring that up about my brother, I don't know if we can talk about this, but
no.
He was talking about.
I'm not taking evidence on your brother's case.
No.
All right. What are you trying to tell me?
I was gonna bail him out if he in case he.
That's up to you guys. That's up to you guys. I haven't seen him yet, so his initial appearance is going to take place literally in the cell block after this recording. So, I can't find I go to him. So I don't know what's going to happen yet. I'm just letting you know because of his probation situation and all of the overall facts in his case, he's very likely to get a bond today. Doesn't mean you can't go post it for him.
How high do you be?
What's that?
How high do you be? Because I got like 700 in my property, in his property.
Right now, I'm looking at 950. So go talk, see what it is when you get out, and just don't miss any of your court dates, okay?
Okay.
All right, good luck, sir.
Thank you.
All right, Mr. Singh? And then Mr. Kewanimtua, will you please go to the chair? Right here, sir. Hi, can I have your full name and your date of birth, please?
Gurkaran Singh, March 30th, 1997.
Okay, thanks. You're here on a new case. You're arrested for 1 allegation of assault, 2 allegations of disorderly conduct. Those are all 3 Class 1 domestic violence misdemeanors. There is probable cause for them, and I am appointing a lawyer for you. You won't meet that person until your next court date in the Goodyear City Court, which will be June 18th, 2 weeks from now at 1 in the afternoon. The address in Goodyear will be on your paperwork. Now, in your case, my main concern is that you stay away from the alleged victim. And I have considered a victim impact statement that was filed, and it sounds like the alleged victim does not want to see you stuck in jail. She just wants you to live somewhere else and stay away from her, which is the normal kind of order that we would issue. You do not appear to have any criminal history. And I would think, assuming you are indeed a medical student at U of A, you would have a strong motive to show up for court, not catch a warrant, and defend yourself in this case, because any type of conviction could impair your ability to succeed in your chosen profession. So I hope that's an added incentive to comply. Because if you violate this order in any way that could be probable cause for harassment, you could be arrested for felony harassment because it's in violation of a no contact order in a pending criminal case. So I'm telling you that just to add more incentive not to do it. Don't contact her. Don't respond to contact from her. The other family members are victims on the disorderly conduct, which would include your other sister. And I think that's who it is. It's your 2 sisters, one of whom is also an assault victim on the way that the law works. So I'm planning to release you. I want you to find a new place to stay. Sounds like you maybe have one that you told pretrial you've got a relative you can stay with. That's fine. You can do a civil standby with law enforcement to collect some belongings from this residence, but you can't go there on your own. If you have another family member, like a parent or even your uncle, who could go to this house and pack up some things for you, that's okay, as long as you think they can do it peacefully. But the only way you can go is if you bring a Goodyear officer with you. You call them, you tell them you need a civil standby. They do it every day. They'll want to see your paperwork. Once they see that I've allowed it, they'll send an officer to go with you and keep the peace while you grab your important stuff. So then just no weapons, drugs, or alcohol while the case is pending. And even if you get contacted by one of them first, don't respond. They can't give you permission to violate the court order. I think one or both of them may physically be here, and so they're probably listening out in the thing. So I want to tell them, even if they contact you, you're not to respond. And if anybody gets an order of protection and you get served with it, then you have to comply with that as a term of release in this criminal case. But if that doesn't happen, then that just doesn't apply. So your court date is in 2 weeks at 1 in the afternoon. I almost said in the morning. 1 in the afternoon in Goodyear. All right, any questions?
Do the president members have anything they'd like to let you know? Have they already submitted
No,
their
right, no. I do have a written victim impact statement that will be available to you through the state, like in your disclosures. And it's,
now?
What's that?
From at this point?
Correct.
Okay.
And so that's what I'm saying is it makes clear they don't want to have contact with you, but it also says they don't wish for you to face jail time. And so I interpret that as that they're okay if you get released without a bail, but they still want a no contact order, which is completely normal. And if I had never received that statement, I would 100% have given a no contact order. And that this is very standard because these domestic violence cases are pressure cookers. And so the person who ends up arrested, as to whom there's probable cause, they do get ordered to move. And that is all day, every day. And it can be hard and it can be inconvenient, but we take it very seriously. So should you. And the point is to keep the peace. You're innocent until proven guilty. I've given you a lawyer, but you won't meet them for 2 weeks. So just keep the peace. Do not get accused of violating release conditions, because you'll take a bad situation and make it much worse. If the police arrest you for violating this, they could book you just on a misdemeanor for violating this order at all. It could even be a felony if it's an act as to which there's probable cause for harassment. And I try to tell people that can be less than you think. That could be one text saying, thanks a lot. If a cop books you for harassment, it's a felony and you're going to get a bond. You know, the court worries a lot about domestic violence cases because even statistically speaking, when people have that much history with one another, release conditions tend to get run over. So, eye on the ball on the big picture, which in my book for you would be a medical degree. This could jeopardize that. So don't do anything to make this situation worse, okay? Just go talk to your lawyer. Don't have any contact with them. Don't try to influence their testimony. That's a felony. Don't make this worse. It's not great, but it's not the end of the world. Just don't make it worse, okay? All right. If you'll take your paperwork, you should be out in a few hours. It's slow to get released, but you'll be out later today. What's your question?
Thank you for all that information, Your Honor.
Sure.
I really appreciate it. One more question. I know you mentioned if I follow all this process that I might...
Many outcomes are possible.
I might still get, my medical degree.
Sure.
And I'm just curious, beyond that, like residency as well, will this affect,
Oh, that is such a complicated question. And I am very sorry to say it's a lot more complicated today than it was a year ago. And we both know what I'm talking about. And so that is something that, of course, in your position, if you're here, are you here on a student visa?
No, I'm
a
citizen.
Oh, good. You mean residency as a doctor?
Residency as a
I
doctor.
thought you meant residency in the U.S.
Yeah.
Because I was going to say, oh my, yes, honestly, all bets are off on that. But if you're a citizen, you're good to go. Oh gosh, sure, no, and I've lived a long life, and I've been around hopefully longer than what it looks like. And I've been through, I've been a lawyer a long, long time. I think there's a lot of doctors running around with an imperfect criminal history. How imperfect, I don't know. But certainly you should have a strong motive to avoid ever taking a conviction. And there are many outcomes. There are diversion programs. You could beat this at trial. There are, or even if you get convicted, there's opportunities to explain when you go to a licensing board, et cetera, et cetera, et cetera. So I would just certainly encourage you to know that this is just the beginning. It's a long, it's a long road, and many outcomes are possible. You will only make it worse if you do anything to get accused of violating release conditions, because as I noted, you are innocent until proven guilty, but these court orders apply even if you're innocent. So if you violate them, if you were to do anything that could be booked as harassment against the alleged victim, that's a felony. Even if you were acquitted at trial of the underlying case, you could still be found guilty of the felony harassment because you were under a court order. So just keep all of that in the forefront of your mind. Don't violate court orders. Don't miss your court dates. And that will help keep the peace. It will help keep the victim safe. And you can move on with your lives. You're going to be siblings forever this court case is temporary. So focus on that. Do not, assume that this is going to be the end of everything. I tell people that not because I want to appear biased toward defendants, but only because people who lose hope, they tend to make bad decisions. I don't want you to make bad decisions because you think, well, it's all over anyway. It's not by a long shot. So don't make the situation any worse. Go deal with it, and that's about it. Okay.
Thank you so much,
All right.
Your Honor.
If you step to your left, you take the paperwork. All right, Mr. Kawanintiwa. And then Jonathan Herwick, will you go to the chair? Hi, sir. Can I have your full name and your date of birth?
Alex Quinton Kiwanimtua, January 7, 2003.
Okay, thanks. You're here on a new case. You got booked in for disorderly conduct, a class 1 misdemeanor. There is probable cause for it. I am appointing a lawyer for you. Your next court date is going to be in the Peoria City Court, June 24th, which is 3 weeks from now at 9 o'clock in the morning. That address is on your paperwork. Okay. And I'm planning to release you on your own recognizance as well. And your no contact orders are going to say the following. I'll let you comment on it, but it'll say, your children are, it's in parentheses, I don't know how many you have. Your child or children are not included in this order. You may contact the alleged victim only by email or text messaging and only regarding issues directly involving the parenting of the child or children, with no harassment to occur even if the messages are related to parenting issues. You may have in-person contact with the alleged victim only to accomplish exchanges of the child or children by prior arrangement through email or text, and you may not discuss any matters outside of parenting issues during that contact. Okay. So that would allow you to text or email her and say, I'd like to see whatever, do you have one kid or two? Or
I have one.
One, okay. I'd like to see the baby, like if you guys are not agreeing, it's gonna get ugly. Don't violate court orders. Do not say words that might sound like harassment, because guess what? You're doing it in writing, and guess what will be Exhibit 1 in any family court case you end up in. So never forget. That's the purpose of the email and texting, is so it can be proved. Did you or did you not violate this order? So if you say, by the way, I've always been mad at you about X, bang, you're not talking about parenting issues, you violated the order, cop could arrest you for it. But you could say, how about Saturday, this date, let's meet at the Circle K. You go to the Circle K. She hands you the baby and says, he just ate, I just changed his diaper, here's his medicine, I think he's a little fussy. Like you could say baby things to each other. Or when's he going to daycare? Can you pick him up from daycare? That's all okay. I'm only permitting that because what you're accused of is not so terrible. If it was any more than this, I would just say, you can't contact her at all. And if that means you can't see the baby, then I'm sorry, you can't see the baby for a while. Okay. But on this type of case, what you're accused of, even if you were 100% guilty of that, I think you're probably likely to be able to comply with this and not be a danger to, I don't know if it's your spouse or your girlfriend, but not be a danger to her. So don't do anything to indicate that you are a danger, okay? Yes, ma'am. You can do civil standby to collect belongings, but you can't stay there while the case is pending. No weapons, no drugs without a valid prescription. Do you have any family in town that can help you exchange the baby or help you watch the baby?
I got family in town.
Good, because family can help you, can make this a lot easier as well. Like if you've got family where you say, okay, drop her off at my mom's, thanks, and then you never even have to see the alleged victim. You can just trade off the baby while the case is pending, and then you can still see your child, okay? All right. Everything's on your paperwork, and if you step to your left, he'll give you a copy of that.
All right, thank you, Your Honor.
Thank you. And Mr. Herwick? All right, good morning, sir. Well, it's afternoon now. Good afternoon, sir. Can I have your full name and date of birth?
Jonathan Peter Herwick, 11/5/1979.
Okay, thanks. You're on a new case. You got booked in for possessing narcotic drugs and drug paraphernalia. I am appointing a lawyer for you. Your court dates are going to be in 2 weeks. The first one is June 19th at 8:30 in the morning. That's a status conference. Your preliminary hearing will be June 23rd at 8:30. And you are going to be released because I didn't, for purposes of this hearing only, find probable cause. It does not mean the case is dismissed. It just means you're entitled to be released. And I probably would have done that anyway on this type of charge with you, but you don't have any other release conditions because it didn't find probable cause. So the law says Not that the case is dismissed, it says you're just entitled to be released. So, don't miss your court dates. I gave you a phone number on your paperwork that you can call a few days before just to see if the case is going forward, because sometimes they wait for lab results. And so that might save you a trip to court if you call a few days in advance. Everything you need to know is on your paperwork. Still takes a few hours to be released. Try to be patient, okay? He's got that for you. All right, then, I did receive info from the Sheriff's Office that Mr. Jason Arriaga has been isolated for being combative while in custody. So I am going to go conduct his initial appearance in person, in-house, immediately following this recording. I advise Mr. Jason Arriaga that he got arrested on new allegations and a probation hold. In the new case, he was accused of narcotic drug possession, class 4 felony, and drug paraphernalia possession, class 6 felony. There is probable cause for those. I am appointing a lawyer for it. Status conference will be June 10 at 8:30 in the morning with a preliminary hearing, June 12 at 8:30 in the downtown Superior Court. I'm currently inclined to set bail in his probation case. So in this case, I would just set a $50 placeholder bond to ensure that he's eligible for credit for time in custody. Then in the probation case, he's on probation for a class 3 felony. I'll let him know there's going to be a petition to revoke filed. I am appointing a lawyer for him. His court date either way is June 11th at 8:30 in the morning in the downtown Superior Court. And I am inclined on his criminal history and these facts to set bail in the amount of $900 secured with written conditions I will go over with him. If anything changes after I conduct this initial appearance in-house, I'll update my final written order. It's not the court's intention to update the recording. Now we will stand a recess until 2 p.m. this afternoon.
All right.
Oh, no. Thank you, everyone. Please be seated. I'm right on time. Look at me go. Okay, good afternoon, everybody. My name is Commissioner Hughes. This is the 2 p.m. initial appearance calendar for Wednesday, Tuesday? What's today? Wednesday, June 4th. The court's orders for the taking of DNA samples and fingerprints issued on the first calendar of June will apply to all of the hearings on this calendar. Okay, as we get started here this afternoon, I will call each of you into the courtroom one at a time. I'll ask one of you to stand behind this gray podium here in front of me in the courtroom. I'll ask the next two people I intend to call into the courtroom to line up in the two chairs right inside this door. If you will, please listen carefully for your name and follow through the chairs into the courtroom. I promise you all that will make this calendar move much faster, and then everybody can get to where they need to get to after this calendar a little bit sooner. All right, once you work your way into the courtroom and you're behind the podium, I will start by asking you to state your full name and date of birth. Then I will explain to you why you're here this afternoon. I will tell you whether you qualify for a court-appointed lawyer to represent you. Those lawyers are sometimes called public defenders. I want you all to know that in a criminal case, you have the right to the assistance of counsel. Whether or not you qualify for a public defender, you always have the right to hire private counsel to represent you if you choose to. So if you don't qualify for a court-appointed lawyer, you will have to hire a lawyer to represent you. If you do qualify for a court-appointed lawyer, you absolutely have every right to have that public defender represent you, but you also still have the right to hire private counsel in lieu of the public defender if you wish to. After we talk about lawyers, I will give you the next court hearing dates and times that you'll be required to attend after this court hearing. And the last thing that we'll do while you're in the courtroom is talk about whether you are legally eligible for release from custody. If you are, we will go over on what terms and conditions you could be released. In addition to that right to the assistance of counsel, in a criminal case, you all also have the right to remain silent. These are recorded criminal proceedings. That means anything that you do choose to say in the courtroom this afternoon will be preserved on the recording, and it can be used against you at any point down the line in these proceedings. Unless you have already made arrangements with a private lawyer to represent you here this afternoon, there will not be a lawyer in the courtroom for your defense. Because you will not have a lawyer in here, and because anything you say could be used against you, I will strongly caution all of you against making any statements regarding the facts about why you're here. I encourage all of you to save any questions, statements, comments, concerns you have about the facts that brought you here for a hearing. Save those for a hearing where you have a lawyer present that you can discuss those facts with before you make any statements outside the presence of counsel that could be used against you. Last thing I'll tell you all before we get started is that all of the information that I give you while you're standing in the courtroom will be contained in a written document. That document is called a release order, and you'll get handed a copy of that when you're done in the courtroom and you step back into that room. Please keep that document with you wherever you go from here. As long as you keep that, you'll still have access to your court dates and times and all the conditions we talk about while you're in the courtroom. And that way you don't have to memorize that information so that, you know, later down the road, tomorrow, next week, you still have that paperwork, you can still refer back to it. All right, let's go ahead and get started. If we could, please, can I have Adam Vasquez all the way into the courtroom behind the gray podium? Patrick Wheeler, if I could ask you to have a seat in the first chair right here inside this door. Lorenzo Belmarez, if you would please work your way to the second chair. All right, sir, can I please have your name and date of birth?
Adam Vasquez, August 10, 1979.
Thank you, Mr. Vasquez. You are here on an allegation of a new charge. The allegation against you is one count of aggravated driving under the influence. It is a Class 4 felony. I have found probable cause to support that allegation, and I have appointed the Public Defender's Office to represent you. Your next court hearings will be a status conference June 10th, and then you'll have a preliminary hearing June 12th. Those two hearings will be at 8:30 in the morning. They'll both be in the Superior Court downtown. Because this new allegation is a felony offense that is alleged to have occurred while you were on release in a different felony case, you're not eligible for release on this new allegation. That means you will be held in custody without bond at least until you have an evidentiary hearing. That hearing is scheduled for June 11th at 1:30 in the afternoon. Between now and that hearing on June 11th, you will be held without bond. Do you understand that information?
Yeah. I was going to tell you, ma'am, what they give me for if I wasn't drinking or something, I was going to work and going to...
Start over. I didn't hear what you said.
I was trying to see what they give me on that. For I know I was driving, but I was going back to work. I went to get something to eat. They said I made a turn. But
are you asking what law enforcement has alleged was the basis for the traffic stop?
Yeah.
Let me see if I can tell you.
Well, I mean, they drug test me. They did the things on there, but...
So the allegation is that you made an improper turn, and that was the basis for the stop. Was that your question?
Yeah, that's what I'm saying.
Okay.
Okay, that's what they got me for?
Well, the allegation is aggravated driving under the influence. So the criminal allegation is that while you were operating that vehicle, you were allegedly under the influence.
Influence of what? I wasn't doing. I didn't drink nothing at that time.
Talk to your lawyer.
That's what I was trying to say.
So law enforcement provides for me a factual basis for me to determine that if what they say in their document is true, it would establish intoxication. I am not legally required for purposes of probable cause to determine what substance you were under the influence of, only if there are alleged facts that would support intoxication. So they being law enforcement, in their document that they provide to me called a Form 4, they go through the different field sobriety tests that they allegedly put you under and outline your performance, and based on those allegations, it would substantiate being under the influence.
They got me on that because I work at a tire shop every day. I was tired. They did me like I work every day.
Save that information for your lawyer.
Okay, I'm trying to see.
This hearing today does not determine that you are guilty. I am not finding that you did in fact commit this violation. What I am finding is that the information provided to me by law enforcement, if proven true and if admissible at a trial, could meet the legal elements of the alleged crime. You have every right to challenge the information provided by law enforcement, and certainly you have the right to present evidence in your own defense, but that'll happen once you get a lawyer and down the line in the proceedings.
So there's no bond, you said, man.
You aren't bond eligible. No, under Arizona law, I can't do anything other than hold you without bond at least until that bail hearing.
I run that tire shop. I'm the only one who runs the tire shop.
Yeah, I can't. There's nothing that I have no authority to do anything other than hold you without bond. Okay, any final questions, Mr. Bond? All right, thank you very much. You can step back and get your paper. Patrick Wheeler, if you would please work your way into the courtroom. Mr. Belmares, if you'd please move over to the first chair. Can I please have Candace Gales in the second chair? May I please have your name and date of birth?
Patrick Wheeler, ma'am.
And what's your date of birth, Mr. Wheeler?
10/21/02.
Thank you. You are here on allegations of new charges. The allegations against you are 3 counts of aggravated assault, all alleged felony allegations. 1 count of disorderly conduct involving weapons, also an alleged felony allegation. 3 counts of disorderly conduct, 3 counts of threatening and intimidating, and 1 count of causing criminal damage. Those last 7 counts are all misdemeanor allegations. I have found probable cause to support all of those allegations, and I've appointed the Public Defender's Office to represent you. Your next court hearings will be a status conference June 10th, and then you will have a preliminary hearing June 12th. Both of those hearings will take place at 8:30 in the morning. They will both be in the Superior Court downtown. On these allegations, I have imposed a $100,000 secured appearance bond based primarily on substantial concerns for the safety of the alleged victim or victims in this case. Secured appearance means that you do have the opportunity to use a bonding company to post that bond if you choose to. If you do post that bond and you are released from custody, you are prohibited from returning to the scene where these alleged events took place. You cannot, under any circumstances, have contact with any alleged victims or witnesses. You are prohibited from possessing any weapons or consuming any alcohol or drugs without a valid prescription if you are released. And whether or not you're released from custody, you are ordered to strictly comply with the terms of any orders of protection if any have been or are later served upon you. Do you understand all of those conditions?
Yes, ma'am.
Okay. Thank you, Mr. Wheeler. You can step back and get your paperwork. Lorenzo Belmares, if you would please work your way into the courtroom. David Orozco, can I ask you to please work your way to the second chair? Can I have your name and date of birth, please, sir?
Lorenzo Reed Belmares, 9/15/97.
Thank you, Mr. Belmares. You are here on allegations of new charges. The allegations against you are 1 count of use of an electronic communication device in a drug transaction and 1 count of possession of a weapon by a prohibited person. They are both alleged to be Class 4 felonies. I have found probable cause to support both of those allegations, and I've appointed the Public Defender's Office to represent you. Your next court hearings will be a status conference June 10th and then a preliminary hearing June 12th, both at 8:30 in the Superior Court downtown. On these 2 allegations, you have a $50,000 secured appearance bond. If you post that bond and you are released from custody, you are ordered not to possess any weapons and not to possess or consume any drugs without a valid prescription. Do you understand those conditions?
Yeah, I just don't understand because first I was told I was charged with the S6, which was the sales of communications or whatever on a phone. And then I was...
That's one of the allegations, but pursuant to the statute, it's a Class 4 felony, not a Class 6 felony.
Okay, and then I was like, the prohibited possessor, there's nothing found in my house or...
So the allegation, the prohibited possessor allegation in this case is not about anything found on you at the time of your arrest. The allegation is that law enforcement has photographs of you in possession of firearms during a time period that they allege you were a prohibited possessor. So same thing I told the first gentleman, I am not determining that those in fact happened, that is in fact true. What I'm determining here for purposes of this hearing is if that is true, if it meets the prohibited possessor elements. And it would, assuming that's true. Again, you have every right to dispute that. You have every right to present evidence in your defense. That'll all happen once you get a lawyer, though, down the line.
I don't qualify for pretrial or nothing, services.
Not based on your past criminal history.
I figured.
Any other questions?
No, that's it.
All right, thank you, sir. Oh, shoot. Okay, Candace Gales, if you would please work your way into the courtroom. Tiana Luster, if you would please work your way to the second chair. May I please have your name and date of birth?
Candace Gales, 5984.
Thank you, Ms. Gales. You are here on allegations of new charges. The allegations against you are 1 count of aggravated assault, a Class 3 felony, and 1 count of disorderly conduct, a Class 1 misdemeanor. I have found probable cause to support those allegations, and I've appointed the Public Defender's Office to represent you. Your next court hearings will be a status conference June 10th and then a preliminary hearing June 12th. They will both be at 8:30 in the Superior Court downtown. On these allegations, you have a $50,000 secured appearance bond. If you post that bond and you're released from custody, you cannot return to the scene where the underlying events allegedly took place. You cannot have contact with the alleged victim or any alleged witnesses. You are prohibited from possessing any weapons or from consuming any alcohol or drugs without a valid prescription if you're released. Last thing, whether or not you are released from custody, you are ordered to strictly comply with the terms of any orders of protection if any have been or are later served upon you. Do you understand those conditions?
Yes, ma'am.
Okay, thank you, Ms. Gales. You can step back and
Can I ask, that's my residential home with my children, and I'm a property manager and I need my clothes. How do I get my clothes from there?
So if you post that bond and you're released from custody, you can have 1 civil standby to retrieve items at that location that you might need. Please keep in mind, Ms. Gales, these are temporary release orders until you get to the judge that will see you for the rest of this case. So I am not telling you that you cannot, under any circumstances, ever go back to this location. What I'm saying is between now and at least your first court hearing on the 10th, if you're out of custody, you can only go back 1 time to retrieve items. Okay, if you do that, please know you have to have a law enforcement officer escort you there. So you can do that by calling the non-emergency number to any local police agency. Say, hey, I have a court order not to go back to this location, but I get a civil standby. They'll tell you how to meet with an officer to get back to that location. Okay. If you do that and you need to go back there, please retrieve anything you have there that you might need between now and the 10th, because you can only do that 1 time.
Got it.
At least until after the 10th.
Got it.
All right, anything else?
No, ma'am.
All right, thank you, Ms. Gales. You can step back and get your paperwork. David Orozco, if you would please work your way into the courtroom. David Escobar Martinez, can I ask you to please work your way to the second chair? Can I have your name and date of birth, please?
David Orozco, 10/8/97.
Thank you, Mr. Orozco. You are here on an allegation of a new charge. The allegation against you is 1 count of aggravated assault. It is a Class 4 felony. I have found probable cause to support that allegation, and I've appointed the Public Defender's Office to represent you. Your next court hearings will be a status conference June 10th, and then you'll have a preliminary hearing June 12th. They will both be at 8:30, both in the Superior Court downtown. On this allegation, you have a $15,000 secured appearance bond. If you post that bond and you are released from custody, you cannot have contact under any circumstances with the alleged victim. Under no circumstances are you permitted to reside at the same location as the alleged victim. If me prohibiting you from having contact with the alleged victim and residing with that person means that I'm ordering you not to return to your primary residence, same information I provided the last woman that was up here. You can go back to that location if you need to retrieve any personal items between now and the time of your first hearing on the 10th. But if you do that, 1, you can only do it once, and 2, you have to have a law enforcement officer escort you. So if you do need to go back there, please don't just take it upon yourself to go there to retrieve your items. Please work that out with law enforcement, have an escort when you go. If you are released from custody, you're also prohibited from possessing any weapons or consuming any drugs or alcohol, drugs without a valid prescription or alcohol. And last, whether or not you're released, you must strictly comply with the terms of any orders of protection, if any have been or are later served upon you. Do you understand all of those conditions?
Yes, Your Honor.
Okay, thank you, Mr. Orozco. You can step back and get your paperwork. Tiana Luster, if you would please work your way into the courtroom. Tanner Huffman, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Tiana Luster, 12/20/1997.
Thank you very much, Ms. Luster. You are here on 6 different matters. The first one is a bench warrant issued by the Superior Court when you failed to appear at a status conference in an existing felony drug case. In that case, you have a lawyer already assigned to represent you. That lawyer will continue to defend you. Your next court hearings on that existing drug case will be a new status conference on June 10th and then a preliminary hearing June 12th, both of them at 8:30 downtown. On that existing felony case warrant, you have a $2,700 secured appearance bond. The next 4 matters that you're here on are all bench warrants that were issued by the probation court when you failed to appear at a non-witness violation hearing. Excuse me. In all 4 of those probation cases, you also already have a lawyer assigned to you. So the lawyer assigned to you in each of those cases will continue to represent you. Your next court hearing in all 4 of the probation cases will be a new non-witness violation hearing. It will be June 10th at 8:30 in the probation court downtown. On each of those 4 probation warrants, you have a $500 secured appearance bond. So that's $2,000 total for the 4 probation warrants. The last matter that you're here on is a failure to appear warrant issued by the Peoria Municipal Court on a misdemeanor assault case. On that misdemeanor warrant, you're entitled to a court-appointed lawyer for purposes of release conditions. That lawyer will be appointed for you by the Peoria judge at your next court hearing. Your next hearing on the Peoria misdemeanor warrant will be an arraignment hearing June 10th at 9 a.m. in the Peoria Municipal Court. On the Peoria warrant, you have a $100 secured appearance bond. So your total bond for all 6 matters that you're here on is $4,800. It is all secured appearance. If you post that and you're released from custody, you cannot possess any weapons or any drugs without a valid prescription upon release. Do you understand those conditions?
Yes, ma'am.
Okay. Thank you, Ms. Luster. You can step back and get your paperwork. David Esquivel Martinez, if you would please work your way into the courtroom. Christian Mount, if you please work your way to the second chair. May I please have your name and date of birth?
David Esquivel Martinez, February 16, 2004.
Thank you very much, Mr. Esquivel Martinez. You are here on allegations of new charges. The allegations against you are 1 count of narcotic drug possession. It is a Class 4 felony, and 1 count of failing to admit you were carrying a deadly weapon. That is a Class 1 misdemeanor. I have found probable cause to support those allegations, and I've appointed the Public Defender's Office to represent you. Your next court hearing will be a status conference June 10th, and then you'll have a preliminary hearing June 12th. They'll both be at 8:30 in the Superior Court downtown. On those 2 allegations, you have a $2,500 secured appearance bond. If you post that and you are released from custody, you are prohibited from possessing any weapons or any drugs without a valid prescription. Do you understand those conditions?
What was the bond thing again?
It's a $2,500 secured appearance bond. Secured appearance means that you have an option to use a bonding company to post that bond. If you want to pursue that option, when you get back into the jail, there's a list of bonding companies and their phone numbers posted in various different places. You can find one of those lists and call one, two, or all of those companies if you want to see if you can find a bonding company that'll work with you.
All right.
All right. Thank you, sir. You can step back and get your paperwork. Tanner Huffman, if you would please work your way into the courtroom. Scott Hazlip, if you would work your way to the second chair, please. Can I have your name and date of birth, please?
Tanner Huffman, 10/21/06.
Thank you, Mr. Huffman. You are here on an arrest warrant that was issued after a direct complaint was filed. A direct complaint is a written document that alleged new allegations against you. Well, a new allegation. It's only one. The allegation in that direct complaint is one count of being in control of a means of transportation unlawfully. It's a Class 5 felony, and the direct complaint alleges that it was committed October 21st of 2024. I have appointed the Public Defender's Office to represent you against the allegation in that complaint. Your next court hearings will be a status conference June 10th and then a preliminary hearing June 12th. They'll both be at 8:30, both in the Superior Court downtown. On that warrant, you have a $2,500 secured appearance bond. If you post that bond and you are released from custody, you are ordered not to possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
So I'm being charged with something that was told on my birthday? That was my 18th birthday.
So then, yeah. So it looked, I mean, I don't know the facts because the factual presentation was made to a different judge. I'm just seeing you on the warrant, but the warrant says, yes, that the alleged offense date was 10/21/24, and the charge is being in possession of a means of transportation unlawfully. So when you get to your next hearing on the 10th, on June 10th, your lawyer will be present for that hearing. Your lawyer will have access to the full factual presentation that supports that. So if you think that there's some error or something wrong with that, your lawyer can look at that, and then you can talk to your lawyer about that to potentially get any errors corrected. Do you have any other questions?
No.
All right. Thank you, sir.
Thank you.
Okay, Christian Mouse, if you would please work your way into the courtroom. Destiny Rivera, if I could ask you to please work your way to the second chair. Can I have your name and date of birth, please, sir?
Christian Mouse, 01/24/83.
Thank you very much, Mr. Mounts. You are here on allegations of new charges. The allegations against you, well, you're here on two different matters. First is allegations of new charges. Those allegations are 2 counts of narcotic drug possession, 1 count of dangerous drug possession, and 1 count of drug paraphernalia possession. They are all alleged to be Class 4 felonies. I have found probable cause to support those 4 allegations. Your next court hearings will be a status conference June 10th and then a preliminary hearing June 12th, both at 8:30 in the Superior Court downtown. I have appointed the Public Defender's Office to represent you. On these new allegations, you have a $500 secured appearance bond. The second of the 2 matters that you're here on is a probation violation warrant. In that case, a petition to revoke your probation alleges that you have violated terms 3 and 5. I have also appointed the Public Defender's Office to represent you in the probation proceedings. Your next court hearing on that probation warrant will be a revocation arraignment hearing June 11th. It will also be at 8:30 in the Superior Court downtown. On the probation warrant, you have a $1,500 secured appearance bond. So your total bond for both cases will be $2,000. It is all secured appearance. If you post that and you are released from custody, you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yes.
Okay, thank you very much, Mr. Mouse. You can step back and get your paperwork. Scott Hazlett to the podium in the courtroom, please. Gerald Barrett, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Scott Hazlett, August 6, 1994.
Thank you, Mr. Hazlett. You are here on a bench warrant issued by the Superior Court when you failed to appear at a not guilty arraignment hearing. That is involving a case that has pending felony drug allegations. You have a lawyer already assigned to you in that felony drug case. That lawyer will continue to defend you. Your next court hearing will be a new arraignment hearing. It will take place June 11th. It will be at 8:30 in the Superior Court downtown. On this warrant, you have a $1,000 secured appearance bond. If you post that and you are released from custody, you cannot possess any drugs without a valid prescription once you're released from custody. Do you understand those conditions?
Yes, so I'm here till...
If you don't post that bond, you'll stay in custody at least until your next hearing on the 11th. Whether or not you will be released without posting that bond after your next hearing will be up to the judge you see on the 11th. All right, thank you, Mr. Hazlett. You can step back and get your paperwork. Destiny Rivera, if you would please work your way into the courtroom. Joab Perez, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Destiny Rivera, 6/14/91.
Did you say 91 or 81?
91.
91. Thank you, Ms. Rivera. You are here on a bench warrant issued by the Superior Court when you failed to appear at a status conference in an existing felony drug and felony shoplifting case. You have a lawyer already assigned to represent you in that case. That lawyer will continue to defend you. Your next court hearings will be a new status conference June 10th and then a preliminary hearing June 12th. Both of those hearings will be at 8:30 in the Superior Court downtown. On that warrant, you have a $500 secured appearance bond. If you post that bond and you're released from custody, in addition to getting yourself to your next court hearings, you are ordered not to possess any drugs without a valid prescription. Do you understand those conditions?
Yeah.
All right. Thanks, Ms. Rivera. You can step back. Gerald Barrett, if you would please work your way into the courtroom. Edward Kitterman, if you'd please work your way to the second chair. Can I have your name and date of birth, please, sir?
Gerald Barrett, 1/29/1988.
Thank you, Mr. Barrett. You are here on allegations of new charges. The allegations against you are 1 count of narcotic drug possession, a Class 4 felony, 1 count of drug paraphernalia possession, a Class 6 felony, and 1 count of resisting arrest, a Class 1 misdemeanor. I have found probable cause to support those allegations, and I've appointed the Public Defender's Office to represent you. Your next court hearings will be a status conference June 19th and then a preliminary hearing June 23rd. They will both be at 8:30 in the Superior Court downtown. Mr. Barrett, I'm inclined to release you to the supervision of pretrial services without having to post a bond.
Thank you very much.
If I do that, I do need your assurance that you will voluntarily and willingly get yourself to your next court hearing.
Of course.
Okay, then I will release you to pretrial services. Once you're out of custody, in addition to getting yourself to those court hearings, you're also going to be able to, or be required to contact pretrial services.
Yeah, it'd be like probation.
Kind of. The primary purpose of pretrial services is to support you and facilitate you in your court appearances.
Okay.
So with your paperwork, you're going to get a packet from them.
Yeah.
Please keep it. It will have all of their contact information in there.
Okay.
Once you're out of custody, get to your next court hearings, call them, make them your first call. Today's, I think we decided Wednesday.
Yeah.
So you may not reach them today because I think they close at 5 and it's about 2:30 right now. But tomorrow, give them a call, see if there's anything they require you to do. And then once you're out, don't possess any drugs without a valid prescription.
No problem.
All right. Thank you, Mr. Barrett. You can step back and gather all your paperwork. Joab Perez, if you would please work your way into the courtroom. Michael Arnold, if you'd work your way to the second chair. Can I have your name and date of birth, please?
Joe Perez, 7/26/1998.
Thank you, Mr. Perez. Did you pronounce your first name Job?
Yes.
Is there an A in it, though?
Yes.
Okay. I just wanted to make sure we had it spelled correctly because it sounded like it was pronounced differently than it's spelled.
Yeah, it was spelled wrong previously to it, so it was a J-A-O-B.
I have it spelled as J-O-A-B. Is that the proper spelling?
Yeah, they just corrected it up there.
All right. I want to make sure we get it right in the court record, so it sounds like it's right. But it's just pronounced Joe.
Yes.
Okay. Now, I'm sorry. I got so caught up on your name pronunciation, I missed your date of birth. Will you give it to me one more time, please?
7/26/1998.
Thank you, Mr. Perez. Okay, you are here on an arrest warrant that was issued after a direct complaint was filed. A direct complaint is a written document that alleges new allegations against you. The allegations in the direct complaint in your case are 1 count of possession of a weapon by a prohibited person. It's a Class 4 felony.
Mm-hmm.
And 1 count of interfering with judicial proceedings by disobeying a court order. That's a Class 1 misdemeanor.
Okay.
Those 2 offenses, according to the direct complaint, are alleged to have been committed September 20th of 2024. I did appoint the Public Defender's Office to represent you against those allegations. Your next court hearings will be a status conference June 19th and then a preliminary hearing June 23rd. They will both be at 8:30 in the Superior Court downtown.
Okay.
I am inclined to release you to the supervision of pretrial services without the requirement that you post a bond. If I am to do that, I do need your verbal affirmation, if you will, that you will voluntarily and willingly get yourself to those next 2 court hearings. If I release you without a bond, will you get yourself to court on the 19th and the 23rd?
Yes, Your Honor.
Okay, then that's what I will do. I will release you to pretrial services. Once you're out of custody, you'll be required to make contact with them, so keep the packet you get from pretrial with your release paperwork. Also, once you're out of custody, you cannot possess any weapons or drugs without a valid prescription. And if there are any orders in place, whether they're orders of protection, orders against harassment, you must strictly comply with the terms of those orders unless and until they expire or are rescinded by the court that issued them.
Okay.
Okay, any questions for me, Mr. Perez?
No.
All right,
No, ma'am.
thank you very much. You can step back and get your
Thank you.
paperwork. Edward Kitterman, if you would please work your way into the courtroom. Joshua Leon, if I could have you work your way to the second chair.
Ma'am?
Can I have your name and date of birth?
Ed Kitterman, 1570.
Thank you, Mr.
And I
Kitterman.
do have a attorney, he just couldn't make it here on this short notice, please.
Okay, is your full legal first name Edward?
Yes, sorry.
All right, thanks, Mr. Kitterman. Okay, so you're here on an allegation of a new charge. The allegation against you is 1 count of interfering with judicial proceedings. It's a Class 1 misdemeanor. Because it is alleged to be a domestic violence misdemeanor, you are entitled to a court-appointed lawyer. So I can do one of 2 things. I can indicate that you have declined a public defender and you can hire your own lawyer, or I can say that you're entitled to a court-appointed lawyer and that lawyer will stay on the case until your lawyer can file a notice of appearance. Do you want to waive a public defender or do you want me to leave one on? It may not matter if your lawyer is ready.
That's over my head.
The difference is if you waive a public defender and something were to happen between now and when your lawyer can officially appear in this case, you wouldn't have a lawyer. If I say that you're entitled to a court-appointed lawyer and hypothetically speaking, something legal happens in your case tomorrow and your lawyer hasn't yet made an appearance in this case, the public defender is still representing you.
Okay, so that's
in the
safer. Safety net?
It leaves you represented until your lawyer can. So what has to happen is your lawyer has to notify the court that he or she is representing you. So it sounds like he or she couldn't make it here today. That's fine. And he or she is probably very well versed in filing notices of appearance. But sometimes it takes a while and there can be a delay between when that happens and when the court officially recognizes that you've hired private counsel. So what I'll do then is I will make a determination that you're entitled to a court-appointed lawyer. The court-appointed lawyer will stay on this case to defend you until your lawyer notifies the court that he or she intends to take over. Then that public defender will withdraw. All right, your next court hearing will be an arraignment hearing June 24th. It'll be at 9 o'clock in the morning in the North Valley Justice Court. I am inclined to release you on your own recognizance. If I am to do that, I will need your assurance that you will voluntarily get yourself to court on the 24th at 9 o'clock. I also will order you not to return to the scene where you were arrested, not to have contact with the complainant, not to possess any drugs without a valid prescription, any weapons, or consume any alcohol. And you will be ordered to strictly comply with the terms of any orders of protection currently served upon you, or if any are later. Okay, if I go with these release conditions, do you agree to abide by them and get yourself to court?
Absolutely.
Okay, then I will do that. I will release you. You will be required to comply with all of those conditions. All of that information will be in your paperwork. So please keep that, share that with your lawyer if and when you meet with him or her once you're out. All right, any questions, Mr. Kidman? All right, thank you very much. You can step back. Michael Arnold, if you would please work your way into the courtroom. Jorge Espinoza, if you'd please work your way to the second chair. Can I have your name and date of birth, please, sir?
My name is full name Michael Dwayne Arnold, date of birth August 21st, 1980.
Thank you, Mr. Arnold. You are here on an allegation of a new misdemeanor offense. The allegation is 1 count of driving on a suspended, revoked, or canceled driver's license. I did find probable cause to support that allegation. Because that is a misdemeanor allegation, you're not entitled to a court-appointed lawyer to represent you. You do still have the right to hire a private lawyer if you wish to be represented. Your next court hearing will be an arraignment hearing June 19th. It will be at 1:30 in the afternoon. It'll take place in the Encanto Justice Court.
Okay.
I am inclined to release you on your own recognizance. If I am to do that, upon release, you would be ordered, first and foremost, to get yourself to court on the 19th at 1:30, and second, not to operate a motor vehicle if you do not, in fact, have a valid driver's license.
Yes.
Do you understand those conditions and agree to abide by them, Mr. Arnold?
I completely understand it, and I will abide by it.
Thank you very much. Then you can step back and get your paperwork. You'll be released without having to post a bond.
Thank you.
Joshua Leon, if you would please work your way into the courtroom. Cecilia White, if you'd please work your way to the second chair.
Good morning, Your Honor.
It's afternoon. Good afternoon.
Oh, good afternoon.
Can I have your name and date of birth, please?
Joshua Leon, date of birth, October 2nd, 2004.
Thank you very much, Mr. Leon. You are here on a failure to appear warrant issued by the University Lakes Justice Court. The underlying allegation in the case that warrant was issued on is driving on a suspended license. It's a misdemeanor allegation. Because that is a misdemeanor offense, the nature of that charge does not entitle you to a court-appointed lawyer. If you don't already have a lawyer working with you in that case, but you want one, you will have to hire a lawyer to represent you. Your next court hearing will be an arraignment hearing June 24th. It will take place at 1:30 in the University Lakes Justice Court. I am inclined to release you on your own recognizance. If I am to do that, you would be responsible for getting yourself to court on June 24th, and you would be ordered not to operate a motor vehicle upon release if you don't have a valid driver's license. Mr. Leon, do you understand those conditions, and do you agree to abide by them?
Yes, Your Honor.
All right, then I will release you. Go ahead.
I have a valid driver license.
Okay.
I also had a warrant out for my arrest for the Tempe, from the Tempe Police Department.
Okay.
And as soon as I got the email, I told my work, and they let me go get all that situated. And I got it recalled, and I didn't know I had another warrant out because I had 2 tickets of it, but I had lost that second ticket for the warrant today.
Okay.
So I never knew I had to go over there. And I never got an email or a letter, but I did get a letter and an email at my address, which is the 201 West Hermosa. That's been my address since 6th grade.
Okay.
And I'm graduated and everything already. So I'm just kind of confused, like, why I didn't get that.
Yeah, I don't know the procedural history of the case because it wasn't a Maricopa County Superior Court case.
Okay.
So talk to the Justice Court when you go to your hearing on the 24th. I don't know if maybe they have a bad address for you. I don't know how you would have known about that hearing. It might have been in the initial citation. If you lost the actual paperwork the cop gave you on scene, it could have been in that.
Okay.
So I don't know how you were supposed to have known that there was a hearing that you didn't attend, but that's why this warrant was issued, and then why that warrant wasn't picked up by another court, like if you were seen in Tempe. I don't know if other jurisdictions routinely run warrant checks, and because this is a different court than the Tempe Municipal Court, they may not have known about this warrant. So you're going to get out of custody. You don't have to post a bond, but get yourself to that court hearing on the 24th and try and get all those questions can be answered by that judge, and then you can get this case cleared up and back on track.
I'm very familiar with Judge Kane. He's the one that's been handling me since the beginning. Is that the University Lakes judge? No, I've never been to the university.
It looks like the judge that issued the warrant is a judge by the name of Tyler Thomas Kissel, maybe?
Yeah, no, I don't know that judge. I met you now and Judge Kane.
Is Judge Kane the Tempe City judge?
Yes, Your Honor. And when I got that warrant, he helped me get the recall, and he took me to like the criminal court, and then I showed them my valid driver license after I finished all my classes and all that stuff.
That might happen also in the University Lakes Justice Court. I don't know what their procedures are, but get yourself to that court hearing, and I'm sure that judge will get you back on track in that case.
I'm all good to go, no jail time?
Well, I'm only seeing you on that failure to appear warrant. So I'm not seeing you on the underlying allegation. I'm just telling you that court issued a warrant for your arrest that will eliminate the warrant, and it'll get you another court date before that judge.
Okay, but I won't be serving no jail time?
Well, you're not going to be held in pretrial custody right now.
Okay.
Whether you would serve jail time on the underlying allegation or not, I don't know. That would be up to the court that sees you on that underlying allegation. But here today, you're going to be released from custody. You haven't been convicted yet.
Okay, I was just wondering. Thank you.
Yeah, okay, you're welcome. You can go ahead and step back and get your paperwork.
You have a beautiful day.
Jorge Espinoza, if you would please work your way into the courtroom. Dennis Williams, if I could ask you to please work your way to the second chair.
Hi, Your Honor. My name is Jorge Antonio Espinoza, August 20, 1991.
Thank you very much, Mr. Espinoza. You are here on allegations of new charges. The allegations against you are 2 counts of failing to admit you were carrying a deadly weapon. They are both Class 1 misdemeanors. I did find probable cause to support those allegations. Because both of them are misdemeanor offenses, the nature of those charges does not entitle you to a court-appointed lawyer. You do still have the right to counsel. If you wish to have counsel defend you, you'll just have to hire a lawyer to represent you. Your next court hearing will be an arraignment hearing. It will be June 24th at 1:30 in the afternoon in the West McDowell Justice Court. I am inclined to release you on your own recognizance. That means you would be required to get yourself to that court hearing on June 24th at 1:30. You would also be required upon release not to possess any drugs without a valid prescription. Do you understand those conditions and agree to abide by them?
Yes, I understand and agree.
Okay, thank you, Mr. Espinoza. You can step back and
I have one question,
sure, go ahead.
though. Will they give me instructions as to where exactly to go and all that?
Yeah, so the address to that court will be in your paperwork.
Right, okay.
I think, is West McDowell in the Downtown Justice Compound? So I think that's one of the courts where you'll walk in and there will be several windows. So there'll be, it'll say, I don't know, Encanto Justice Court, West McDowell Justice Court, El Centro Justice Court. There'll be a little label above the windows. So when you go to that address, walk in the door, find the label that says West McDowell, and then just check in at that window and they'll give you further instruction.
Okay.
All right, thank you, sir. You can step back and get your paperwork. Cecilia White, if you would please work your way into the courtroom. Jesus Tarango, if I could ask you to work your way to the second chair. Can I have your name and date of birth, please?
Cecilia White, 5681.
Thank you, Ms. White. You are here on an arrest warrant that was issued after a direct complaint was filed. A direct complaint is a written document that alleges new allegations against you. The allegations in that direct complaint are 2 counts of aggravated driving under the influence. They are both Class 6 felonies. They're both alleged to have been committed November 14th of 2021. I have appointed the Public Defender's Office to represent you against those allegations. Your next court hearings will be a status conference June 19th and then a preliminary hearing June 23rd. Both of those hearings will be at 8:30 in the Superior Court downtown. I am inclined to release you on your own recognizance on these allegations. That would mean, first and foremost, that you would be responsible for getting yourself to both of your next court hearings. You would also be required not to possess or consume any alcohol or drugs without a valid prescription upon release. You would be prohibited from operating a motor vehicle if you don't have a valid driver's license. And if you do have a valid driver's license and you operate a motor vehicle upon release, you cannot do so with a passenger under the age of 18 in the vehicle. Do you understand all of those conditions and agree to abide by them?
Yes. Can I say something? I never received any court papers for neither one of those things, and I did do a forwarding email, an address.
Forward?
Yeah.
Okay.
Yeah. And I still haven't received anything.
So I don't know. I can't undo how you got here. I don't know whether something was mailed to you and potentially returned, or if the court just went straight to a warrant in this case.
Okay.
Sometimes they will file a direct complaint, issue a summons, mail it out. If somebody doesn't come to court, then they issue a warrant.
Okay.
Sometimes when a direct complaint is filed, they being the county attorney's office, the county attorney's office will file the direct complaint and then just go straight to asking the court to issue a warrant. I don't know which path this case took. All I know is we're at the warrant phase now. So when you went through from booking to getting into the court, when you went through that process, did you have an opportunity to provide your current address to pretrial? Okay. So we'll have your current address on file now. You'll also have a lawyer present to represent you when you get to court on the 19th. So make sure you get to court on the 19th. If there are still problems or if there are problems with your address, your lawyer can get them all cleared up with the trial court that's going to see you on the underlying allegations.
Okay.
Okay. Anything else?
No.
All right. Thank you, Ms. White. You can step back and get your paperwork.
Thank you.
Dennis Williams, if you would please work your way into the courtroom. Kelton McCowan, if you'd please work your way to the second chair. Good afternoon. Can I please have your name and date of birth?
Dennis Williams, January 2nd, 1986.
Say your date of birth for me one more time, please.
January 2nd, 1986.
Thank you, Mr. Williams. Okay, you are here on an allegation of a new charge. The allegation against you is 1 count of dangerous drug possession. It is a class 4 felony. I have not found probable cause to support that allegation. My reading of the information provided to me by law enforcement is that the allegation is that you, upon arrest, were in possession of fentanyl. I believe that fentanyl is a narcotic drug under Arizona law, not a dangerous drug. So I don't believe that there is probable cause to continue to hold you on a dangerous drug allegation. But I want you to understand, Mr. Williams, that my finding of no probable cause does not mean that the county attorney's office will not correct that and file a formal charge potentially on a narcotic drug allegation. So because there is a possibility that the county attorney's office will file charges as a result of this arrest, I am going to determine that you're entitled to a court-appointed lawyer. I'm going to appoint a public defender to represent you. I am going to release you from custody without any restrictions or conditions except for one, and that one condition is that you attend court hearings. So you will be required to attend a status conference on June 19th, and then depending on what happens on the 19th, maybe also a preliminary hearing on the 23rd. When you go to court on the 19th, there will be a lawyer present to represent you. That's when you'll find out whether or not charges have been filed. It is possible that the court will tell you nothing's been filed, you're free to go, you don't have to come back on the 23rd. But if the county attorney's office does file charges and you're not in court on the 19th, that court will issue a warrant for your arrest. So you're going to get out of custody, you've got a lawyer as a result of this arrest. Please make sure that you go to court on the 19th at 8:30 downtown in the Superior Court.
Okay.
Okay, do you understand all that information?
Yes.
Do you have any questions?
No.
All right, thank you, Mr. Williams. You can step back and get your paperwork.
Okay.
Jesus Tarango, if you would please work your way into the courtroom. Can I please have your name and date of birth?
3/15/1987, Jesus Tarango, Alberto Tarango.
Thank you, Mr. Tarango. Okay, you and I are going to have a similar conversation to the last gentleman that came up. You're here on an allegation of a new charge. The allegation against you is 1 count of criminal trespassing by looking into a residence. It's a class 1 misdemeanor. I did not find probable cause to support that allegation. My reading of the information provided to me by law enforcement indicates that there would have been probable cause for criminal trespassing, but I did not, if it were booked under a different subsection of the statute. I did not see any factual support that law enforcement alleged that you were looking into a residential structure. So because of that, I'm not finding probable cause to support this allegation, but my finding of no probable cause doesn't mean that the county attorney's office cannot file charges under a different subsection. So similar situation, you're going to be released from custody without restrictions other than one, and that one restriction is that you go to court. So your court hearing will be an arraignment hearing June 24th at 9:30. It'll be in the White Tank Justice Court. When you show up at that court hearing, you'll find out whether or not formal charges have been filed. If they have been, that court will then determine whether you're entitled to a court-appointed lawyer and give you next steps. If no charges have been filed, you'll also find that out. But if you don't show up at that hearing and charges are filed, that court's going to issue a warrant for your arrest, which means at some point you'd have to come back through here and do all this again. So you're going to get out of custody. Make sure you go back to court or go to court on the 24th at 9:30. Okay, do you understand that information? Any questions, Mr. Tarango?
What if it was pre-trial services? Does that matter?
Does it matter for what?
No.
Does that change what I'm saying? No, because I'm not finding probable cause to support the alleged offense.
Thank you.
So that's the reason that you're getting out of custody. If I had found probable cause, then your current status in maybe other cases might have mattered. But because I think you were booked under the wrong subsection, I never got to that second stage of the analysis.
Thank you.
All right. Thank you, Mr. Tarango. You can step back and get your paperwork. Kelton McCollum, if you would please work your way into the courtroom. You can set that down wherever you want. You can put it right up there if you want. Okay, yeah, that's great. Can I have your name and date of birth?
Kelton McCollum, 10671.
Thank you very much, Mr. McCowan. Okay, you are here on a parole violation warrant issued by the state of California. Before you were put on a court docket here in Arizona, Arizona confirmed with California that is a valid warrant. California has indicated that they intend to extradite you, which means they want to come to Arizona and take you back to California. I know the answer is yes because I just saw you walk in with it, but did you get that big laminated card to review? That one right there?
Oh, yeah.
Yeah. And did you have an opportunity to read through that?
Yes.
Okay. Here's what's going to happen. Your hearing's going to look a little bit different than everybody else's because you have a choice to make. So I'm going to go through what the two different options for you here are. Hopefully they match the information on that card. I will then give you an opportunity to ask any questions that you have about either option, and then I will ask you which of the two options you would like to pick. Okay. You have, like I said, two different options. The first option you can pick is to waive your right to an extradition hearing and agree just to go back to California. If you pick that option, you are not waiving any rights or defenses you have to the California proceeding. You're only waiving your right to an extradition hearing here in Arizona, and you're agreeing that California can come here and take you back to California. If you pick that option, you will be held in custody here in Maricopa County for up to 30 days to allow California authorities an opportunity to come get you. In that 30-day time period, you would not be bond eligible. The second option that you can pick is to choose to have an extradition hearing held here in Arizona. If you pick that second option, I will set an extradition hearing for June 16th at 1:30 in the afternoon. In Arizona, extradition proceedings are civil, not criminal. That means I could not appoint a lawyer to represent you if you picked option 2 and I set that hearing, but you would have the right to hire a lawyer to represent you if you wanted to have one. If you pick option 2 and I set that extradition hearing, because it is a parole violation warrant, you're still not eligible for release from custody. So regardless of which option you pick, you will stay in custody without the opportunity to post a bond. The difference will be the duration. So if you pick option 1 and you waive your extradition hearing, you stay in custody for up to 30 days. If you pick option 2 and you have that extradition hearing on June 16th, warrants are then sought by the governors of California and Arizona. It is once both of those governors sign their warrants that California is authorized to come to Arizona and Arizona is required to release you to California. That time period from your initial extradition hearing to getting warrants signed by both governors could take up to 90 days. You would stay in custody without bonds that whole time. So option 1 is you waive your right to a hearing, stay in custody.
Option 1.
You want to go with option 1? Okay. Because you are waiving a legal right that you are entitled to, I need to ask you some questions for purposes of the recording. All I ask is that you answer them out loud as opposed to nodding or shaking your head. Okay, question number 1. Did you read the waiver of extradition paperwork on that big laminated card?
Correct, yes.
Do you understand you do not have to sign the waiver of extradition paperwork?
Yes.
Do you understand you have the right to demand an extradition hearing?
Yes.
Do you understand you have the right to hire a lawyer if you elected to have an extradition hearing?
Yes.
Do you understand that you have the right to demand that governor's warrants are signed by both states before you could be involuntarily returned to California?
Yes.
Do you wish to give up those rights and sign the waiver of extradition paperwork?
Yes.
Has anybody offered you anything or promised you anything in exchange for your signature on the waiver?
No.
Have you had any drugs, alcohol, or medication in the last 24 hours that you believe affects your ability to waive a legal right?
No.
Okay, then I will find that you are knowingly, intelligently, and voluntarily signing the waiver of extradition paperwork. I will also sign it. Once we both sign, I will ask MCSO to notify California that you are ready to return. They will have 30 days to come get you starting tomorrow. Do you have any questions before I ask you to step to your right and sign?
No.
Okay, then unlike everybody else, if you would please step up here to your right, I do need you to sign that waiver. You can bring that down. Okay, number 3 on the calendar, Shamika Gibson, date of birth 1/8/94, is not in the courtroom because she was unable to function in general population. due to combative behavior. She is here on two different matters. The first is an allegation of a new charge. That allegation is one count of being in possession of a means of transportation unlawfully, a Class 5 felony. I appointed a lawyer to defend her in that case. Her next court hearings will be a status conference June 10th and then a preliminary hearing June 12th, both at 8:30 in the Superior Court downtown. On that new allegation, she has a $5,000 secured appearance bond. She's also here on a probation violation warrant. A petition to revoke her probation alleges that she has violated terms 3 and 5. I've appointed a lawyer to represent her in the probation case. Her next court hearing will be a revocation arraignment June 11th at 8:30. On the probation matter, she is not eligible for release on bond. Number 22 on the calendar, Ivan Anaya Herrera, date of birth 3/10/89, is not in the courtroom because he poses a danger to himself. He is here on an allegation of a new charge. That allegation is one count of being in possession of a means of transportation unlawfully, a Class 5 felony. I have appointed a lawyer to represent him. His next court hearings will be a status conference June 10th and a preliminary hearing June 12th. They will both be at 8:30 in the Superior Court downtown. Because that is a felony allegation alleged to have been committed while he was on pretrial felony release, he is not eligible for release on bond, at least and until a bail hearing is conducted. That hearing is scheduled for June 11th at 1:30 in the afternoon. Last on the calendar, number 24. You can go ahead and step back.
The time here, the 30 days?
Yes.
Like, say 6 days, they come get me, would that count?
Will it count towards what?
Good credit?
So they could come on day, I mean, they could come tomorrow. They can come anytime in the 30 days. You'll have to check with a California lawyer as to, if your question is, are you entitled to credit for time served in Arizona on the California case, you'll have to ask your California lawyer. If that were Arizona, if you were convicted in Arizona and then incarcerated in California, an Arizona court would give you credit for time served, but I don't know enough about California sentencing law. So just talk to your California lawyer about that. And also keep track mentally, if you would, of the number of days you're serving here, in case you are entitled.
Thank you.
You're welcome, sir. Okay, last on the calendar, number 24, Benito Coronado Franco, date of birth 5/1/85, is not in the courtroom because he was unable to function in general population due to combative behavior. He is here on allegations of new charges. Those allegations are one count of possession of a weapon by a prohibited person, a Class 4 felony, and one count of resisting arrest, a Class 1 misdemeanor. I did find probable cause to support those two allegations, and I've appointed a lawyer to represent him. His next court hearings will be a status conference June 10th and then a preliminary hearing June 12th. They'll both be at 8:30 in the Superior Court downtown. On those allegations, he has a $15,000 secured appearance bond. If anything changes after I visit any of those individuals' cell sites, the court's final orders regarding their release conditions will be reflected in the court's written release order. Okay, that concludes the 2 p.m. initial appearance calendar. This court will stand in recess until 5 p.m.